अ, अ, कहते नाम पे तस्दीक करोगे चलते हैं?
उसके ऊपर जाके इफ यू कैन जस्ट सब मैं किसी को भेजती हूँ। हाँ, हाय अनिल जी, नमस्ते।
नमस्ते नमस्ते जी। नमस्ते मनोज जी।
हाय अनुराधा जी।
कुमार साहब नमस्कार।
नमस्कार अनिल जी, हाउ आर यू?
वेरी वेल जी, वेरी वेल। आशीष जी कैसे हैं आप?
I am good. I'm good. How are you?
वेरी वेल जी, वेरी वेल।
Very, very good afternoon. On this, I would not call it a sultry afternoon because for us, it's really a very cozy and a comfortable afternoon because we are all sitting here to understand more nuances of the IBC law. And what better than actually coming together and having so many esteemed and prestigious organizations joining hands to bring this program to all of you. It is not an event, it is not a program, or it is actually a workshop where we will try as a group. And of course, when we have Kumar sir with us, who has been in the forefront of actually driving and diving into the IBC, who better than him who will actually take us through it as a chief guest. But first and foremost, let me do the honors by calling the names of the organizations. So we have the All India Insolvency Professional Association coming together and joining hands with the Chartered Accountants Association Jalandhar, Punjab, the NCLT Kolkata Bar Association, the MSME Development Forum West Bengal, the JIPA Professional Association New Delhi, the Association of Practicing Cost Accountants New Delhi, and the Kerala Insolvency Professionals Forum Kochi, which is very active also. We all have come together to bring this to you. And our honorable chief guest today is none other than Shri Justice Kumar sir, retired, and whom we know very well, whom we have seen in and out in the way he used to take, and he's still into the center of IBC. We'll introduce him in a bit, but sir, thank you very much. Please accept our gratitude for your presence, for your time, and for all the well-wishing that you have for the associations. As speakers, we have Advocate Ashish Mukhija ji. Thank you, Ashish ji, for your time. We have Mr. Manoj Kumar Anand, who's the president of All India Insolvency Professional Association, and who's also actively doing a lot of work and also contributing a lot of his time and energy for IPA. We have Mr. Anil Goyal, the advisor to IPA. I am the secretary. I don't know worthwhile or not, but that is what I designated as. And we have Mr. Nilesh Sharma as the vice president of IPA. I'm sure he'll join soon. So we are here today not to take much of your time, but we are going to delve into the basic and very important two honorable Supreme Court judgments in the cases of Greater Noida and the Bharti Airtel, which is dated 12/2/2024 and 3/1/2024 respectively, and many more, because we'll give you the updates as to what has happened in the very recent past. So with this, we once again welcome our chief guest, Shri Kumarji. Who doesn't know him? He has been into the forefront of so many things and has been the Chief Justice of the Jammu and Kashmir High Court on 8/6/2012. And apart from that, let me tell you, he's our own person, because that is how we look at him. He had taken over charge as the chairman of the Company Law Board on 5th June 2015 and continued as such till 31st May 2016. And with the advent of IBC, he was appointed as the first president. I've had many occasions to see him as the first president to set up the office of NCLT, and how administratively the charm that he has and so many hats that he wears, he actually made the operational part of NCLT so very well. So when the Company Law Board was abolished, he took over as the first president of NCLT, and during his tenure, 28 benches of the NCLT started functioning from 14 states. He demitted office on 5th January 2020, and thereafter he resumed his arbitration and consultancy practice in New Delhi. Friends, I must tell you, he joined the NHRC as member on June 2, 2021. Thank you very much, sir, once again. Sir, without much ado, we'll request you to kindly deliver your address, and then we'll go on further with the program.
Before sir start, I would like to share with my all audience that today is the birthday of Albert Einstein, who perpetuated quantum theory. Or हमारी in our fraternity, IBC has been perpetuated by Sir Mr. Kumar. So we are lucky enough to have this coincidence today. Sir, welcome. We welcome you a lot from all IP community. Please, teach us with your fine words.
Thank you so much. Thank you. Mr. Manoj Kumar Anand, President, All India Insolvency Professional Association. Dr. Ashish Mukhija, who is an eminent author and jurist, and books authored by Mr. Mukhija are read all over. Then we have another eminent personality, Mr. Anil Goel, who has been at the forefront in the continuous education of IBC and corporate law. We celebrated 100th webinar series recently at India Habitat Center. And the beauty of the series is that every week, no matter what, whether he was traveling by air, he was traveling by train, or there was a wedding, show must go on. That is what Mr. Anil Goel is. He has never stopped. And then Dr. Mamta Binani, who is the secretary of the association. She is a very dynamic person. I know her as president of Institute of Company Secretary. She was at the forefront and she brought many new initiatives in the company, in the Institute of Company Secretary. Then we have Chartered Accountant Shri Nalish Sharma. He is also very eminent in his profession. Friends, I am extremely lucky and feel very happy that these type of seminar and webinars are being continuously held by enterprising chartered accountant, IP insolvency professional, in order to bring home the ideas and the latest knowledge through speakers like Dr. Ashish Mukhija. It is your devotion to this profession that the courts are guided, the arguments are modulated accordingly, clients are benefited, the rate of filing appeal, because there would be no correction required in the decision rendered by the NCLT, the adjudicating authority. So that is of great benefit. The cascading effect of this education, I think if somebody tries to gauge, I think it is enormous, in the sense that if a correct decision is made, appeal takes very little time to uphold the order of the adjudicating authority, and Supreme Court would hardly interfere. So that is the service which we render to the profession. And having been initiated in the profession by the authorities, we try to serve the professionals by giving back whatever we can in this form. Now, coming back to my days of company law board, those days senior counsel used to appear in company law board, and the work was substantial, but the volume was not that high on account of paucity of members, the volume, the burden of work was there because there were only 6 members, and few benches like Calcutta bench was functioning, Madras bench was functioning. So when the transformation took place on 1st of June 2016, and NCLT, National Company Law Tribunal, was declared to be adjudicating authority for IBC in December 2016, then the challenges started. Because in May 2016, the finance minister was traveling and he was in Tokyo. He called from Tokyo on 27th or 28th of May that we want to operationalize the National Company Law Tribunal. So the government officers rushed to me that this is what the finance minister wants, although he is in Japan, but he has desired that the benches of the NCLT should start functioning from 1st of June. So I was I was taken aback because within 2-3 days, how it is possible to start functioning as NCLT. I told them that there was hardly any infrastructure, there was hardly any manpower, even the stenographers were not available. But then I told myself that in Jammu and Kashmir, when floods came, so I was left with a table and chair and a roof on the head. So we were able to run the High Court in the house of a judge with table and chair, few chairs, and even the handwritten judgments were recorded by our stenographer because sometime the Wi-Fi system would not be available. So I put on the courage and I told myself that let us go ahead and I was able to infuse some spirit amongst the members at that time. And then gradually we had 23 members to start with, 22 or 23. But the team was spirited one. The team had dedication and was able to satisfy. And I must say, we did not have the insolvency bankruptcy regime in the past in the way it is in the insolvency bankruptcy code. There was a little bit of insolvency law under the old 1923 Act in some metropolitan areas like Hyderabad, Bombay, even Delhi. But the way insolvency bankruptcy code unfolded, there was very, very little, very, very few cases. Under the Companies Act, there used to be one section 433E, which was for winding up. There, these things used to be practiced. Whatever I have experienced in the unfolding of IBC, I may share few things with you. The initial teething trouble. So one idea which was mooted by one of the additional secretary of the Ministry of Corporate Affairs, that Companies Act has litigation, director disputes under section 396, 397. That is one type of litigation under the Companies Act. Then merger and amalgamation, a scheme of arrangement under 230, 232(3). So the idea was given that the benches should be splitted. Instead of having mixed benches, that benches are dealing with company law cases as well as insolvency, bankruptcy, let us have exclusive benches dedicated to IBC and exclusive benches to the company law. So there was some discussion on this topic, and my suggestion was that since all members are selected at a common platform, we cannot discriminate, because some member may think that they are being deprived of applying the law, the new law in insolvency bankruptcy code, and other may feel that they are being deprived of applying the company law. So I was able to convince them that let us not create any exclusivity. Rather than you leave it to the president, he will prepare the roster and will ensure that adequate care is taken and there is balance. Otherwise, we will end up in some dissatisfaction amongst the members. So that idea was eventually dropped at the highest level, that we will have only dedicated benches to companies law and the IBC. Another thing which is peculiar to the IBC is there is a lot of delegation. You know, Parliament makes law, and when Parliament makes law, then for certain fringe area, it can delegate that this aspect may be taken care of by the government by issuing rule or notification. In this regard, I will quote the example, but before I quote the example of Section 4, let me tell you that when I ask certain people that why such a huge gap has been created, why so much delegation is there in the Act, the answer was that if we don't give power to the government, sessions of Parliament are becoming difficult. The Parliament doesn't meet at regular intervals, and whenever it meets, there are boycotts. Therefore, it is very difficult to take every amendment to the Parliament. Therefore, we have created this buffer so that the IBC and the company law may keep functioning the way we want, the way the provision has been made. That was the answer given. But now see the impact of this excessive delegation. Section 4 has given the threshold of 1 lakh to start with. And I may share with you that in a country like England, where insolvency bankruptcy code is enacted in 1986, there it is £100 even today. So 1 lakh was the threshold kept, that whosoever is aggrieved by non-payment of ₹1 lakh, he can file an application under Section 7 or 9, and corporate insolvency resolution process can commence. But an amendment was brought just after COVID that this 1 lakh under proviso power is given to the government. Delegation is there under Section 4 proviso, that it can go to 1 crore. So from 1 lakh, it had gone to 1 crore. The fallout is that the MSME sector, the small and medium industry, who keep supplying goods and or the service sector, who work for the big industry, who have the bills, say, of 20 lakhs, 30 lakhs, 50 lakhs, small contractor, they suffer. They cannot. The only course left with them is either go for a civil suit or adopt some other remedy. Even under the Companies Act, when 433E was alive, for a small amount, a company petition could be filed. For a small amount, say 5,000 rupees, 20,000 rupees. So there was no bar, there was no limitation. And rightly so. Why I say rightly? Because a person who is unable to pay 1 lakh, would he be poor than the person who says that I am unable to pay 99 lakhs? What should be the parameter for judging the solvency, or for that matter, insolvency of a debtor? 1 lakh is a better criteria to judge but the reason given is stock reply, litigation increased manifold, therefore it was necessary. In another program, I have also spoken about this, that this is not fair for the MSME sector, because very big industrialists, they give a damn to the demand of 20 lakhs, 30 lakhs. So they eventually go into either arbitration or something else, and their payments are delayed. Then the other delegations, for example, under the Companies Act, IBBI, for example, many things have been delegated to the IBBI. One thing which I wish to share, in the IBC, there is a provision which uses the word shall, that adjudicating authority shall refer to the IBBI where there is no person named by the financial creditor or the operational creditor to be the IRP. So that matter has to be referred to the IBBI, and the period given is within 15 days, the IBBI is required to name the person and send back the case to the adjudicating authority. Now, this process was time consuming. On the one hand, we were required to admit a petition within 15 days from the date of filing. On the other hand, this provision was made that if there is no person named as IRP, then it must go to the IBBI. They will pick up the name, and on the basis of Supreme Court judgment, I suggested to the then chairman of the IBBI, Dr. Sahu, that kindly work out this provision, and we can easily curve the timeline. The time consumed would be much lesser. But at that stage, that was in January 2017, at that stage, Dr. Sahu thought that word shall has been used, therefore it is mandatory. And the parallel judgment which 1967 Supreme Court, which I was showing to him along with other members, that judgment was on the similar lines, where the central government approval was required to be taken before changing the condition of service of an employee under the Reorganization Act 1956. So there Supreme Court said that blanket approval is good enough. So I said that if in that case it can be done, so surely you can do it in this case also. But eventually, IBBI agreed to adopt the procedure of sending the list to all the benches of the NCLT, approved list, and it was on account of the fact that Calcutta bench of the NCLT issued contempt notice to IBBI because there was delay of more than 2 months in appointing the IRP. So that was Mamta must be aware of that case when Mr. BP Singh issued contempt notice, and one of the director was called to appear in person. So these are the telling experiences, you see, which are very educative and gives you a lot of learning. I have so many other things to talk, but I will say that coming to the judgments, one important judgment, apart from the two which this webinar is to discuss one important judgment is by Justice Yashwant Verma in the case of Nitin Jain. Recently, we have discussed this judgment in the insolvency veterans by Mr. Rajesh Sharma, a former member. Here the question is PMLA and IBC, which law to prevail? I'm sure Dr. Mukhija must have seen this judgment. Here the Delhi High Court has taken the view, Justice Yashwant Verma has taken the view with a detailed logic and rationale that IBC will stand and the IRP endeavored to sell the property as a liquidator. His right has been upheld. So the PMLA cannot, under the PMLA, that property cannot be subjected to attachment. So that is the, in nutshell, I am sharing with you, that judgment, appeal against that judgment by 2 judges bench, the acting Chief Justice, has been dismissed. SLP is pending. So that judgment is also very important because these days, PMLA is invoked every now and then, and when the adjudicating authority, NCLT or NCLAT, is seized of the matter, Section 14, moratorium is operating, and the job of the IRP or oblique RP, that cannot be complicated by attachment of the property because the cooling period during the period of CIRP, that cooling period has to be conceded. That is the logic of that judgment. I think that is a correct view taken. And as far as criminality is concerned, that is attached to individual. The successful resolution applicant, he cannot be burdened with those things, or the purchaser of the property in liquidation, he cannot be burdened with those things. That is the logic of that judgment. Then these 2 judgments which you have taken up for discussion today, these 2 judgments are with regard to
Yes, so one is with regard to the Greater Noida Industrial Development Authority.
yes,
Yes, sir.
by Justice Manoj Mishra,
Yes.
and
And the other is with regard to the set off.
I am taking up NOIDA first.
Yes, sir.
If you see this judgment in NOIDA case, firstly, the Supreme Court has reversed the finding. Otherwise, adjudicating authority and the appellate authority has given the finding that claim was not filed by the NOIDA authority, Greater Noida Authority. So that finding is reversed. That claim was filed. That is one. Having said that, they said it was an operational creditor. Supreme Court said no, it has a security interest, it was a secured creditor. Once it is a secured creditor, it has right of participation in COC. And the view that resolution plan met all the requirement of Section 30, subsection 2, Regulation 37 and 38 of CRP regulation. Those requirements were not fulfilled. Therefore, there are holes, gaps. And the order passed by both the adjudicating authority as well as appellate authority set aside, a matter sent back to the COC to have a relook by allowing the secured creditor like Greater Noida Authority to participate. And the most important was they were not given notice. Greater Noida Authority was not given notice. So this is also, so this is a somewhat extraordinary judgment in that sense, that Honorable Supreme Court has gone to the extent of setting aside the findings. One finding that no notice, the claim was filed or not, that finding was reversed. Both the courts held that no claim was filed, but Supreme Court said the claim was filed. And second, notice, no notice was given. That was admitted position. So this judgment is all very, very important from that point of view. Then Justice Sanjeev Khanna's judgment in Bharti Airtel, it is on set off. Whether a person who is filing the claim, a counter-claimant can say that they also owe me this much, it should be set off. The principle of set off has been discussed in great detail. I think from para 3 onward, meaning of set off and types of principles of set off. These are by citing the English law, by citing the CPC, His Lordship has analyzed the whole thing in the context of set off, and ultimately they said set off is a concept alien to IBC because of section 14. So these are the two judgments in lumps. In nutshell, I am saying, because Dr. Mukhija is there to throw greater light on this, and I think I will conclude by saying that these type of seminar and webinar by all professionals should be held continuously, weekly, twice a week, or twice a month, or once a month. You are gaining a lot of knowledge by visiting court every day, by exchanging views with the members and having their views on different topics. And IBC has grown out of proportion. Now, if you see the list, it is amazing. The IBB website show 3 major amendments in the IBC, 30 kinds of rules can be seen on the IBB website, more than 100 regulations and amendments notified by IBBI, 76 circular, 76 notification listed on the IBB website, 98 important judgments are analyzed by IBBI, 40 guidelines issued and listed on the IBBI website, 46 amendment notifications circular issued by other authorities like SEBI, GST, ROC, MCA on the subject of IBC. 53 reports have been made by various committees and can be found on the IBB website. 649 orders and judgment available on the IBB website, out of which 475 are from the Supreme Court and 3,938 from the NCLAT. And no interim order are posted on the IBB. So this is the vast knowledge available. The ocean of knowledge is available. A person like me is only collecting some stones on the seashore, some pebbles on the seashore. So with these words, I thank Shri Manoj Kumar Anand, the President of the All India Insolvency Professional Association, Dr. Mamta Binani, and all other eminent guests today for allowing me to share my views with you and for inviting me to such a illustrious webinar. Thank you so much.
Thank you so much, sir. I think हिंदी में एक कहावत है कि आप गोता मारते हैं समुद्र में, तो आपके आपके शब्दों में आज यही एहसास हुआ, because you really actually brought the time to a standstill and took us back to those 6 years that we have gone through in IBC. Good, bad, medium, we are not into it. This has been a real experience for the country. And with your hands, the way you had taken it forward, we are all privy to this. We have been all witness to this. It's an occasion where we have relived through your own words today. So thank you very much. And pertinently, that you really brought out was the fact of the inclusion of 32A in the IBC, which
Yeah.
actually upheld what you mentioned. So
Jashwant Verma judgment has discussed 32A.
absolutely. We just hope that the country starts coming out of that syndrome of PMLA, because there are still so many cases which is stuck due to PMLA and other such reasons.
Oh, I
So we-
only hope that Supreme Court delivered its judgment at the
Yes.
earlier stage, because
Yes.
Division Bench of Delhi High Court has upheld the view taken by the learned single judge, which I think is the correct view, unnecessarily hampering the, under the, you see, garb of saying the
Crime proceeds. Yes, sir.
the assets
Yes.
which were taken illegally,
Yes, yes.
black money assets,
Yes, yes.
that is not going to help and take us anywhere. Once purchaser is there, then everything is, any culpability has to be left to the earlier management.
Correct.
That's all. Nobody is saying that anybody who has done any culpable act, they should be exonerated. We are not saying that. But IBC should be left alone. That liquidator or the IRP, ERP should be allowed to function properly. Otherwise, everything will come to stands. Same is with the arbitration.
Right,
Some
sir.
arbitration is not allowed to proceed. The Supreme Court has given one judgment in Hotel Godawan, which was my order. The appellate has upheld
Yes.
my Supreme Court. Justice Nariman said, no, there cannot be any arbitration. Section 14 will govern. No, thereafter, so many other judgments has come. No, it can continue if it is for the benefit of the corporate debtor. So those
Yes.
complex situation,
Right.
but adjudicating authority will do once if there are conflicting views
Right.
from the appellate or the adjudicating different benches of adjudicating authority. So this has to be straightened up, creased out properly, so that members are guided properly. They may think, straight.
Yes.
Thank you. Sorry.
Thank you so much, sir. We'll really request you to become the patron member of IPA and keep guiding us, sir. We'll come to you personally on that.
Very well.
And our deep gratitude, sir. Sir, we also have the president of the NCLT Kolkata Bar Association, Shri S.N. Gupta ji, whom you have met.
Yes, Gupta Sahab, I met him.
Yes.
Met Gupta Sahab whenever I would visit Calcutta. There was one seminar also held in Calcutta.
Well,
I
he's
think.
a little indisposed, but just because you were here, he said, no, I'll come and greet him.
No. Thank you so much, Gupta Sahab. Very nice to meet you.
Thank you, sir. Sir, we are straight away now moving with your permission, we'll move on to the next session of updates, which is a very important session that we all look forward to.
Yes, please.
So,
I'd like to raise one very small point with the Honorable Kumar, sir.
yes,
Sir.
yes.
While the act was being authored right from the white paper and other stages, I used to interact with Vishwanathan, the
Yes.
law secretary. And 238 and code, in fact, why it was named as code was something very critical. And it had to be most senior act which was desired. Would you like to give any comment on 238 or the code to make us proud that we are handling a code which is the most senior law?
Well, I think we are following the British legacy. There, if I remember correctly, even in England, they have named it code. So instead of calling it a statute, but otherwise it doesn't make much of difference. You have Indian Penal Code, you have insolvency bankruptcy code. This code maybe that code word is used. I'm not very sure. Maybe traditionally the code word is used when there are penal provisions all over. So maybe because of that, but for that matter, PMLA has very, very rigorous provision. It has never been named as code. So this is what I would say. Otherwise,
Thank you, sir. Thank you so much. Thank you, Mr. Sharma. Maybe please move on to Mr. Manoj Kumar Anand. We'll request him to kindly give us the update session that he always does. Talking about his resume, he's the present president of IPA. He's the one who's also leading it from the front, not only being because of the presidentship, but even otherwise being a great worker. And he has 36 years of experience as a chartered accountant. And as an insolvency professional, he has over 6 years of experience. He's been quite a visiting faculty at different places and quite an avid writer on the subject. Manojji, we request you to kindly take your session.
Thank you very much. Thanks a lot. सर ने काफी कुछ बता दिया गागर में सागर की तरह उन्होंने जो द जजमेंट नोएडा pertaining to Noida which I was supposed to take, he has already covered it to that extent. Now, since we have already reached to 4:15, and a lot of our audience are here to listen to Mr. Mukhija ji more than me, I'll be moving a bit fast. Please bear it with me. Sir, we have a tradition whereby whenever we have the last session, after that, whatever updates are there, I do prepare it and share it with my insolvency professional brothers. Our objective of webinar is is meant to help our insolvency professionals so that they can in the speed of life they do forget or sometimes miss some certain important things, but we culminate all those things and put together there. So I'm starting with my deliberation. Yeah, quickly, please bear it with me. Okay, as far as update is concerned, we being an insolvency professional, we are always keen to know what new opportunities will be coming to us in IBC. MCA makes presentation to the cabinet on cross-border and group insolvency as both are interlinked. If it got notified after coming of the new government, we may have more opportunities in the IBC. IBB expert committee recommends voluntary mediation for IBC. That will also open up a few opportunities of VIPs. Formulate a code of conduct for COC, Delhi High Court to IBBI in the case of Sukam Power System Limited. Whenever we are handling any the IBC assignment, we always have a courtesy or some sort of feeling. Most of the time, COC is quite cooperative, but many a times things the table do turn around. And now it has been the demand of the statute also that we have a code of conduct for everybody, and especially for IPs, it is a very strict. Let some code of conduct be there for COC. Finally, Honorable Delhi High Court has asked that I just give you the brief. In the case of COCOM, what happened that directors of the company filed a case against COC and concerned RP also. Allegation was that this is the company having a valuation of 300 crore rupees, but you're, in liquidation, you're selling it at a price of 10 crore rupees. There is some big hanky-panky. In fact, without going much detail into it, RP has against RP, ABB has also taken some allegation based on the totality of circumstances. Honorable Delhi High Court has directed to the IBBI to have their code of conduct for the COC also. As far as case laws, my second point is case laws are concerned. NCLT, NCLT has power to order release of property attached by the ED after approval of Registration Plan 32A. It was discussed by Honorable Kumar ji, and that is the particular case which I thought of sharing with you. Greater Noida builders revived under reverse insolvency order from NCLT of 1900 units. This is also good for we insolvency professionals because as far as reverse insolvency is concerned, it is not much popular, whereby you mingle with, whereby any freelancer can, take the route of reviving the company through past promoters. So this is, I thought of sharing it with you that in case of in this particular case, 1900 units were delivered. NCLT approves registration plan for Reliance Capital International with upfront cash payment of around 10,000 crore rupees. This is one of the very big plan approved. I thought of sharing with my brothers and other audience also. SpiceJet Airlines strikes settlement on 250 crore insolvency dispute. This is the power of the IBC. That things which otherwise earlier was going on for years and years, and the debtor was never interested in making payments to the creditor. In this case, most probably with the 12A route only, that this particular settlement happened and the company is revived. Another update is on the personal insolvency. 3 months ago, after Jadodia's assessment, this particular personal insolvency law has revived, and all NCLT benches are quite active now. And the law is being, law NCLT decided cases, law will be settled. I've come across two new points for that. One is that in the case of Mr. Vikas Agrawal versus Asian Color Coated Spark Limited and others, NCLT New Delhi held, they delved on the doctrine of subrogation. In the case of, they dealt it there in that under Contract Act, under Section 126, you have a right to be subrogated. That meaning thereby out of subrogation is that you put your, if any personal creditors make payment, then he automatically put his foot in the shoes of the creditor. In this case, Honorable NCLAT has held that if the registration plan provides otherwise, or it doesn't take care for the personal creditors therein, then this right of subrogation can't be there. Another judgment is of CL Sharma versus Bank of Maharashtra and others. In this case, what happened is that when we see the appointments of personal guarantee cases under Chapter 3 of Part 2, therein we have appointments of two types. One is under Section 94, under Section 95. Practically, what is happening nowadays is that if any debtor appoints under Section 94, then 95 creditor files an application that this RP be removed. And if the Section 95 application is filed by the creditor, then the 94 application is being moved. The debtor moves, files an application to remove that particular RP. For that reasons has been provided under Section 98, subsection 294. Honorable NCLT come out that at the time of, before filing of the report under Section 19 and other laid down cases, no adjudication can be done for the appointments of RPs done under Section 94 or 95. Whatever limited power has been given under Section 98, subsection 4, that is only after formulation of committee of creditors and filing of report, and later on only for the when a plan is to be implemented, not before filing of report and all this in there. Pre-package there, and also I was lucky enough to get routed through first case in pre-package in the name of Amrit India Limited from Principal Bench NCLT. The reason of this pre-package is like that you have to submit the base registration plan. Honorable Justice said that it should be submitted along with application. It happened since R was the first application. We argued that it is not required to be, but ultimately we submitted it there. And now NCLAT has held that it is not required to be submitted, because base registration plan once submitted to the Honorable Court, then it will be known to the everybody, and how any improvement plan can after that. We always love to have some international news also. One international news I have is that an Australian property tycoon having a wealth of around 500 crores has also filed business insolvency. I mean to say that insolvency is not only happening in India, but happening abroad also, and that too very, very fast and treated as a normal business practice. Okay, now I come to my main topic, which was my core topic for today. Analysis of Honorable Supreme Court judgment in the case of Greater Noida Industrial Development Authority versus Prabhajit Singh Soni. It was civil appeal number 7590-7591 of 2023, void order dated 12/2/2024. I have prepared my subsequent slides with the objective for the learning of my insolvency professional brothers. Any addition, anything to be added there, and I request all my co-speakers and in fact all my co-participants also to share their thought also wherever they want. We can take it. First of all, that why this judgment is so important. Yeah, earlier, this particular judgment is mainly with reference to the home buyers, but it has some reference to factory owners also, where there is a lease agreement. I read it. Earlier, in the case of home buyers or big factory owners, whereas lease rent was cancelled or non-payment of lease rent, the land owning agencies like Huda, HSIDC, Puda, Noida, Canada, JDA, Mahada, etc., were treated as operational character as per Section 5, subsection 20 of the IBC 2016. No, with this judgment, they may be treated as secured creditor as per section 3, subsection 30 or subsection 31. If they thought of encashing their security interest being land, then whole feasibility or viability of the plan as per section section 30 subsection 2 read with CRIP regulation 37 and 38 may jeopardize. Meaning thereby that in this case only, if you see it Prabhuji's Singh Soni's case only, if NOIDA thought of taking back the land and saying that we don't allow you to have this land there, then the whole home buyers flats will go haywire. And in fact, we have a basic funda in our plan approval that it should be feasible. The feasibility of the registration plan will go haywire. But in any case, they will have upper hand even above home buyers and distribution of asset from subsection E or G to subsection B, subsection 2 of section 53(1). जैसा सर ने अभी थोड़ी देर पहले बताया, because they have become the secured creditor. Along with this, many other issues have also been adjudicated, like recalling power of adjudicating authority, relook on claim submission by RP, planning by RP to get it vacated, this order. It will have a very, very heavy impact on our insolvency proceedings. Before we move further, let me give you very briefly the facts of the case. What happened at the Greater Noida Industrial Development Authority, which in my subsequent slides I shall name as GNIDA. GNIDA allotted plot of land to JNC Construction Limited (CD) as on 28/10/2010 by way of lease for 90 years. This is the common practice. 90 or 99 years lease is there. As usual, CD committed default and GNIDA served demand cum cancellation notice on CD. CRP was initiated against the CD-wide order dated 30/5/2019. Canada filed claim of rupees 43.40 crore in the category of financial creditors. The RP treated Canada as operational creditors and requested to file claim in that category only. Since Canada did not file the revised claim, RP treated the claim of Canada to the tune of 13.47 crore as claim of OC only. The stalemate continue till final adjudicated by the Honorable Supreme Court. Meaning thereby, stalemate was like that. RP COC treated them as OC to the tune of 13.47 crore. Canada said, no, we are the financial creditors to the tune of 47 crores. In the meantime, Russian plan was also approved by the NCLT as on 4th of August 2020. Yeah, it was not 47 crore, it was 43.40 crore. Yeah, another important aspect was that in the IM, RP did not make any disclosure of Canada claim of rupees 43.40 crore. Canada filed an application bearing number so and said against its treatment as OC wide IA to recall the order approving resolution plan. NCLT rejected the application of Canada and appeal filed before NCLT was also rejected. Now let's see what appellant said. What was his logic and what he said. Yeah, their logic was that RP wrongly treated them as OC, ignoring CIRP Regulation 13. CRP Regulation 13 says that he has to simply collate the claim and not adjudicate the claim. No disclosure of their claim as financial category and amount was mentioned in IM. COC did not hear them or made part of it. Approval of a plan by NCLT is not as per Section 31. Section 31 say that it should be compliance of law. No consideration of delay concession granted of 1 year duty corona by NCLT, NCLT, and many more considerations. This we shall, look into it in my later slides. Submissions on behalf of the respondents. Dr. Abhishek Manu Singhi, our senior most lawyer, replied, led the arguments on behalf of the respondents, submitted that RP absolutely acted as per Honorable Supreme Court settled law in the this law was settled in the case of New Auckland Development Authority versus Anand Sonbhadra. According to that settled position, it is not a financial debt and hence no but to COC and challenge to registration plan is sustainable. COC is supreme and stated various case laws in support of that and said that whatever decision has been taken by the COC is unchallengeable because of their commercial wisdom. There is no scope of recall application by NCLT and NCLAT as per the interpretation of the IBC code by them. Further, once the registration plan which makes a provision for the applicant is approved by the adjudicating authority, it can't be questioned through a recall application. This was, this was pleaded by Manu Singhvi ji. The registration plan was approved by the adjudicating authority as on 4th of August 2020, and the successful resolution applicant SRA seeking implementation of the plan informed the applicant white letter dated 24/9/2020 about the plan. Yet IA number so and so was not filed before 6/10/2020, meaning thereby within a stipulated time, and IA number was seeking recall was filed only on 15/3/2021. Say after 6-7 months which shows that the applicant had not been diligent in pursuing its right, if any. Therefore, the challenge post approval of the registration is liable to be rejected. There appears no material irregularity in the approval of the registration plan, particularly when the commercial wisdom of the COC is not justiciable. The Supreme Court, now let's come to the crux of the whole judgment. Whereas what Honorable Supreme Court found in this case and how they adjudicated this thing, the Honorable Supreme Court observed that a court or a tribunal has inherent power to recall an order to secure end of justice or to prevent abuse of process of the court. IBC or regulations framed thereunder don't permit exercise of such inherent power. Section 60, subsection 5, subsection C of the IBC empowers NCLT to entertain or dispose of any questions of priorities or any question of law or facts arising out of or in relation to the insolvency resolution or liquidation proceedings of the corporate debtor or corporate person under IBC. Rule 11 of the NCLT rules preserves inherent power of the tribunal. The Honorable Supreme Court observed that even without empowering prison, a tribunal has power to recall. Power to recall has to be used sparingly, no doubt in that. They held that on limited grounds only, where order is without jurisdiction, party has not been served with notice, or order has been received on misrepresentation of facts or playing fraud on court. The Honorable Supreme Court held that application filed by the Grenada for recall was maintainable as it was not informed about meeting of the COC. The proceedings was ex parte. There was a misrepresentation on the part of the RP, and the NCLT erred in approving the resolution plan under Section 31. The Honorable Supreme Court held that the resolution plan did not meet the requirement of Section 30, subsection 2 of IBC read with CRP Regulation 37 and 38. We as an RP has to certify that a ration plan is meeting the requirements or laws as per Section 30, subsection 2. It was disputed fact that claim of rupees 43.40 crore has been filed. It was undisputed fact. Honorable Supreme Court held that claim was filed by Grenada. Grenada was advised to file claim form B in category of operational creditors rather than form C meant for financial creditors. Assuming that Grenada did not heed the advice, once the case has been filed with proof, the same could not have been overlooked by the RP. Form in which a claim has to be submitted is directory. What is necessary is that the claim should have support with proof, meaning thereby that it has changed the whole process of VRP accepting as a claim. Now we have to go with the substantive evidence therein and then collate the claim instead of being at screwed to that whether it is filed in form C, D, E, F, or although it may fall in other category. As happened in this case, the claim was filed as a financial creditor. RP treated that particular claim as per prevalent law at that time because of Sonbhadra judgment as OC, operational creditors claim. Resolution plan has not only failed to acknowledge the claim made, but also in mentioning the correct figure of the amount due and payable. Resolution plan mentions figure of rupees 13.47 crore, whereas according to Grenada, amount due was rupees 43.40 crore. These aspects have not been considered by Honorable NCLT and NCLT also. The resolution plan also did not put Grenada in the category of secured creditors, although by virtue of Section 13A of 197 Act, charge was created in favor of Grenada. No placement of secured creditor in category of secured creditor has affected adverse interest of the Grenada. Meaning thereby here, I would like to deliberate a little bit that, what happened in the case of Rainbow Judgment also. In the case of Rainbow Judgment, they were treated secured creditor because of the specific provision in the Gujarat VAT Act. In other words, that if that particular act whereby you're filing your claim gives you the power to have a charge of the assets by virtue of statutory powers with you, then you can be treated. But if you revoke those clauses therein, and then you can be treated as a secured creditor. Same happened for the Greater Noida Authority also, as adjudicated by the Honorable Supreme Court. But if you don't have any power in that particular act, then you can never be the secured creditor, only because of the reason that statutory dues are there. Regulation 38, Sub-Regulation 3 of CRP Regulation 2016 provides that resolution plan should demonstrate that it is feasible and viable, and it has provisions for approvals required. When land of the CD belongs to a statutory body, a closer examination of resolution plans of feasibility has to be undertaken. The aspect was not deliberated by NCLT and Honorable NCLT also. मीनिंग देयर बाय कि अगर लैंड ही एक पर्टिकुलर हाउसिंग सोसाइटी की वापस चली जाएगी अथॉरिटी को, ग्रेटर नोएडा अथॉरिटी को, तो देन हाउ दिस प्लान इज वर्केबल, हाउ द होम बायर्स कैन गेट देयर होम्स. Okay, final adjudication in appeal was allowed, and the Honorable Supreme Court sent back the resolution plan to the COC to COC for resubmission after satisfying the parameters provided under the code. Now, what is the take? Now, this is the our analysis, our association analysis. That what is the takeaway for IPs from this judgment? We practicing insolvency professionals need to keep ourselves updated all the time, as provisions earlier settled by Apex Code are sometimes reversed back, as happened therein. Sonabhadra, the provisions has been reversed in this case, in the case of this Greater Noida Authority case. It may again be re-reversed by amending in the IBC 2016 after elections, as IBB has already issued discussion paper on this particular aspect. It was basically on the rainbow paper. And second takeaway is that while collating claim, sports to be given more important than claim from COD, etc. IM must disclose all aspects like claim filed by the stakeholders and collated by him, especially when material amount is involved. Otherwise, it shall not be a Section 30 subsection 2 compliant. इसके बारे में I would like to say that for submission of claim details, Institute of Company Secretaries has given a tabular form. We always follow in our practice therein, whereby this is always written security interest as claim by the creditor, claim passed by the RP, reason for difference in claim and all this thing there. Had that been followed, that particular form has been followed, so RP should not have been criticized to that extent. All election plans passed earlier may require to be revisited in the light of above judgment. This is our subjective opinion. All future election plan must be passed keeping conscious of this judgment, especially feasibility and viability of a plan as per Section 30 subsection 2, read with CRP regulation 37 and 38, meaning thereby if any authority has revoked the prison there and recalled the land, then how the plan will be feasible, how the home buyers will get the flat. Similarly can happen in the case of big factories also, whereby lease deed has been cancelled and particular authority has issued a notice to take back that particular land. Now, what is the way out, or what suggestions we can have share with our IPs? Yeah, another thing is that NCLT shall also examine all the plans for approval under Section 31 in the light of the above judgments. Unsecured financial creditors homebuyer may suffer due to treatment of land on agencies as secured creditors, having priority over them in distribution as per the scheme laid down under Section 53. The judgment shall not only affect real estate sector, but also affect factory owners whose lease deeds has been cancelled. Possible solution. No. Let's look into the possible solutions. RPCOC must endeavor to get vacated the lease cancellation order from High Court, which you can get. Practically, you can get. Or wait amendment in the IBC 2016 expected after election, nullifying this judgment. But here again, the proviso will be there. Again, retrospective amendments may be subject to challenge in court and finally decided by the our honorable courts only. In all probability, all plans shall be put on hold till amendment IBC 2016 is not brought in consonance with the objective of revival and keeping CD as a going concern. अभी हमने PMLA की बात भी करी. Even sir has simply said that this IBC should prevail over all these acts, PMLA also, and most probably for this sort of judgment also, whereby through some involuntarily act, this security interest is being treated. In our opinion, that only security interest created with voluntarily act only should be treated as a secured creditor, instead of, if any, through law or through statute, any involuntarily interest is stated or security is being taken. In that case, the government must have a relook and should not treat it as a secured creditor. Because the priority in payment to secured creditors, if it happens started happening like this, will definitely jeopardize revival and going concern of CD.
Yes. Mr. Anand.
Yes, Kumar.
Yes, sir. Yes, sir, please.
I have to leave. You see, I have one arbitration which I have to attend.
You're with us for such long
I am
time.
so sorry.
Sure, sir. Thank you so much, sir, for your presence. Thank you. Thank you, Kumar, sir.
Thank you very much, sir. You've been with us for more than an hour. 1 hour 20 minutes. Or sir, in future also, agar we shall need your blessing and we shall be inviting you.
Anytime. I'm always there.
Thank you so
You
much.
are doing
Thank you,
very
sir.
well. Thank you so much. All the very best.
Thank you, sir. Thank you.
Thank
Sorry,
you,
Mr.
sir.
Mukhija, I wanted to hear Mr. Mukhija, but I will hear the recording.
Okay.
Thank you so much.
We shall share you, sir, YouTube recording and all this thing.
Yes. Thank you so much.
So we are honored with your presence, sir. Thank you very much.
I feel honored. Thank you.
Okay, I'm continuing. Basically, I have finished this particular judgment.
Yes. Thank you, Manoj. Would you
yeah.
like to say something more?
Only one thing, I shall take 2 minutes only. We at IPA, we always organize some event and we always share this list with everybody. And since we have already taken a lot of time and most of the people are here to listen to Mr. Mukhija. So without, I'm passing it through very, very, very quickly. You can visit our YouTube channel to have a look on it. We always have, a deliberation only on the latest topics. Thank you very much. Thanks a lot. Thank you. Yes, Mamta ji, please take over. I'm stopping my presentation.
Thank you so much.
Please take over.
Without any accolades, because that is a part and parcel of you, the way you take it up. We would just want to say that this particular judgment, I'm requesting all the esteemed guests here to actually go through it. It looks to be a bulky judgment, but actually it is not so. It brings out a lot of contours where basically what we understand is it's very important that the actual facts should be put into the resolution plan. Sometimes, when Namaste Nilesh ji, welcome.
Namaste ji, haan ji, how are
Namaste
you?
Malay ji, namaste.
Thank you for joining in. Sometimes when we actually go through the resolution plan as an RP or as an advocate, we sometimes see, okay, these are portions which are not so important, which has no impact on the commercial aspects of the plan. And we just kind of pass through those pages and we feel how it's going to impact at all. So we feel it's non-cancerous and just go through and leave it there. I'm requesting that when you read this judgment, it actually tells you that please concentrate on every data that gets pulled out from the repository of the RP or its IM. And if it is put in the resolution plan, and if you see that there is a discrepancy there, because it is actually leafing out from your info, then we must make sure and write back to them that this is actually not correct. At least the numericals are not correct. To that extent, we also always must write. In this judgment, we see, and sometimes when you read the judgment, you are not able to appreciate exactly that what has happened in the matter. But one particular aspect that we see is the records, the numbers is not correctly pulled out and put in the resolution plan. And there's not much time today, but we'll deep dive into it some other time. Second is, it writes that had it even been an operational creditor, it would have got so it says that probably not much had been done to even bring it as an operational creditor in its records. Even if it has filed it as a financial creditor, this thing comes out very succinctly when we read the order, that even if the claim form is incorrect, the RP or liquidator for that matter has to treat it as per the RP's understanding in law. So, for example, if somebody is filing a form as an other creditor, other stakeholder, but you need to actually pull it and put it in the right bucket, is what actually comes out from this judgment. So let's get into the other judgment. So the purpose of such sessions is obviously not to bombard you with too much information. What we want that our brains should just set to be in the thinking mode, so that whenever we come across something like this, we actually look at it and think that somewhere we had read it and we need to now understand it better.
Nilesh ji want to say something. Nilesh ji, please.
Yes,
Nilesh ji, इनके बाद अनिल जी और मुखीजा जी, अगर आपको भी कुछ कहना होगा जजमेंट के बारे में, whereby you can add to it, please subsequently add your words also.
Yes, we'll move on to Mukhija ji's session, and then if Nilesh is
first, only on 2-3 minutes I will be taking.
Yes,
so
sir.
2-3 important issues have been decided in this particular judgment. One is whether this claim form, if we receive some claim in the wrong form, So what is to be done by us as an RP? So whether we have to ask the claimant to file the claim in the correct form, or we have to consider based on the information which is given in the claim form, as well as the information which is there available with the CD. So based on the same, we have to consider, even if the claim form is wrong, we still, if in this particular case, they filed the claim form as a financial creditor, but actually the RP should have treated them as operational creditor. There was no need for him to ask the authority, Greater Noida authority, to file the claim in the right form. Rather, he should have considered it based on the information which is there available with him as CD, as also the information which is provided in the claim form. So this is one. And then they say
Proof
that
of claim. You mean the proof of claim?
proof of claim, yes. The claim form is only directory in nature. So if it is in wrong form, you can't, you should not reject it. So this is one. Second, very important issue which has been decided in this order is that whether NCLT can recall, NCLAT or NCLAT, they can recall their orders. So normally, as we know, that tribunals, that they are not entitled to recall their order unless specific provision is there in the law. In IBC also, there is no specific power which has been given. But in this particular case, Honorable Supreme Court says that under certain circumstances, the order can be recalled. They say that if there is a procedural defect, so procedural defect, they say that under certain circumstances, and those have also been, I think, defined by them. One is that in this particular case, they said that appellant was not informed of the meeting of the COC proceedings up to the stage of approval of resolution plan by the adjudicating authority were ex parte. RP misrepresented that the appellant had submitted no claim when otherwise a claim was submitted of an amount higher than what was shown outstanding towards the appellant, and there was gross mistake on the part of adjudicating authority in approving the plan. So based on these things, they directed, they held that yes, NCLT should have recalled its order. Okay, and then they say that if a judgment has been pronounced without jurisdiction, or in violation of principles of natural justice, or where the order has been pronounced without giving an opportunity of being heard to a party affected by it, or where an order was obtained by abuse of process of the court, which would really amount to its being without jurisdiction, inherent powers can be exercised to recall such order. So not in all the circumstances, but only in these particular kind of circumstances. Third issue is that they have treated the authority, NOIDA authority, as a secured creditor. And that is because of that section 13A and all. So they say that they have again recognized the statutory charge. They say, which was upheld by the judgment in the case of Rainbow Paper. So Honorable Supreme Court here says that yes, because there is a charge, they should have been treated as a secured creditor, though they were operational creditors. So this particular aspect has not been again considered by Honorable Supreme Court. They say that Anand Sonbhadra case has already decided that NOIDA authorities' dues will be operational in nature. Okay, so they have not gone into that thing again, and they say that based on their judgment, the Greater Noida authorities' dues will be treated as operational. However, because there is a statutory charge created in their favor by that particular act, by which Greater Noida authority has been created, so their dues should have been treated as secured dues. I think these are the three important things which have been decided by this judgment, and all of us as resolution professionals have to keep these things in mind for future. Right.
Thank you so much, Nilesh.
No, ma'am, can I ask a question?
Yeah,
Yes.
yeah.
Yeah. See, what happens if there is no form which is received? You know, somebody simply sent a mail that this so-and-so company owes me so-and-so much amount. So what to do? See, when it is a wrong form, we can now rely on this judgment. When there is no form, but the information has been given by only way of a mail. So
you can you can check your books of accounts. If in your books of account some debtor is there, creditor is there, and if you are satisfied that this is the genuine creditor, you can you can collate that claim. even if they have not filed it.
So
This
now,
can be a practice. If anything contrary is there, please share other audience with me.
I have my own views, but anyways, like I would like to just put it in the IM by saying that no claim has been received, but by way of a letter, this has been intimated. So, because otherwise, if just a letter would do, then what is the requirement of a claim
Of filing
form?
form exactly.
So I would then, I would but put it in the IM and carve out a separate section in that, list of creditors also by way of an attachment in the list of creditors that, these has come by way of a letter and subject to karke, I'll just put it there, but I'll not actually admit it or something like that because it's then, people will actually lose the significance of filing a claim form. Nileshji, what's your view?
Correct, correct.
Okay.
Yes. So I think
Okay.
the claim is required to be filed.
Yes.
So if somebody is not filing the claim, then I think it will be difficult for an RP to admit the claim. But at the same time, I think he must disclose all these facts in the information memorandum. And already we are having that Puneet Court judgment, wherein Honorable, I think NCLAT has said that even if claim is not there, you must disclose everything in the IM, that these are the cases where claims have not been received and all. So I think claim should be filed, but disclosure should be made in the IM that claims not received for such and such.
Even after this Greater Noida judgment, whereby they very specifically and clearly said, form is not important; it is only the substance which is important. And if your books of account showing that he is a creditor, and he has instead of asking you in a form, he said in a mail that this is my claim, because it can happen with smaller creditors or something like that.
No, sir, I don't
Even then,
think.
you will go like that.
Yes, yes, Manoj.
Okay, fair enough. Fair. Yeah,
One more.
yeah.
If some arbitration arbitration has also already decided for some claim, and it is put to COC for reimbursing the claim, how it is to be dealt?
Yeah, Mukeshji, please hold on. Please hold on. Our very esteemed another speaker is on the fence for a pretty long time. Let us just move on to him, and then of course, Manojji, this question is for you. We'd like to take it at the end of the session. So thank you so much, Ashish ji, for your patience. I must say that's commendable. He's a leading practitioner in insolvency and corporate law matters, and we know him quite in and out. He's been talking to us for a very long time since the advent of insolvency. And before that, I have also seen him while I was the president of ICSI, writing books on company law and so many other subjects. So he's quite an academically brilliant person. And let me give you an insight that he also received a gold medal for obtaining 100% marks in mathematics. My God, the subject that we all run away from. He has written 14 books this far, and the books also include, of course, the insolvencies and the company law, and he's written one on corporate directors, the role, responsibilities, the powers, and the duties. So he's quite an avid contributor of articles, and he has served as a member of the monitoring group of ICSI Institute of Insolvency Professionals. Welcome, Ashish ji. He's also a keen golfer, friends. So thank you very much for your presence. May we request just
I would like to say that with Mr. Ashish Mukhija ji, we have a इनका साथ हमारा IP बनने से पहले से था, because they taught a lot of IPs in Delhi how to pass this exam, and I was lucky enough one of that. And till this time, he's having such a gamut of knowledge with him that whenever you listen to him, you will always find something new. As far as IBC is concerned. Welcome, Ashish Mukhija ji. Thank you very much. We are due apology that we kept you waiting for, that was in our hand. We planned to have your session at 4:15, but it get delayed. Please, our due apology for that. Please carry on.
Thank you. Thank you very much. And I think I must, first of all, appreciate the efforts of all the associations out here. The idea of knowledge and dissemination is extremely important in a field which is IBC, which is a very, very important field, and everyone gets affected with that. So I must recognize the presence of Mamta Binani ji, Mr. Anand, and many other, Nilesh ji, and all other friends. I think this is extremely important that we should get together and try to learn about IBC. Learning together is always fun, right? Friends, as I always request, may I request everyone to please open videos. I don't want to speak to blank screens. It is not a
May we
face
request you to
meeting.
please put on your videos at the request of the
Yeah, I
speaker
think
also.
you see, it's very important that we should. I can see smiling faces, so I also get encouraged by that, right? So I can see a lot of old faces and my friends, my fraternity colleagues. I think it's very important that we should be together. And I was listening to a lot of conversation. I did not interrupt in between. And of course, Honorable Chief Justice M. Kumar, I think he had a wonderful innings at the NCLT and prior to that CLB. And what he did, he established NCLT, which is running based on his, efforts which have been made. So I think let's, without wasting any time, I think let's go to the straight away to the judgment. In fact, I plan to cover two judgments, but it doesn't look that I'll be able to cover two of those judgments. One was, of course, this Airtel judgment, and then second was relating to that DBS Bank, which is also bringing out some controversy in the sense that now it is setting aside the Amit Metallics and India Researchers judgment, and it says we are giving a different view. So therefore, the Honorable Chief Justice has been uh, requested to constitute a higher bench to discuss that particular issue. So let me start with my presentation, and I think from there then we will move forward. Yeah. So
सर मैं
let me start.
पीछे डिस्टरबेंस आ रही है, मैं सबको म्यूट कर रहा हूँ, आप प्लीज अपने आप को अनम्यूट कर लेना प्लीज.
Yeah, okay, thank you. So I hope now everyone is able to hear me.
Yes, sir.
Yeah. Okay, so let me start with this particular judgment, which is Bharti Airtel versus Vijay Kumar V. Iyer. And this was rendered on 3rd January 2024. It's a very relevant judgment, my dear friends, and I think we have to really go to the facts of the case. So without taking too much of time, let's try to understand. In this particular matter, the Bharti Airtel and Bharti Hexacom, these are the two companies, they entered into 8 spectrum trading agreements with Aircel and Dishnet. These were the two companies which had got, the spectrums allotted by the Department of Telecommunications, by the government. And then, of course, they were not able to utilize those spectrums. So therefore, these companies generally enter into a trading agreement because it's like an intangible asset. So they entered into that 8 agreements. And once, because they were entering into that user agreement, so they went to the DOT for approval. Naturally, you require approval of the Department of Telecommunications. So Telecommunications Department put a strong condition saying that please furnish the bank guarantee. Now here starts the problem, right? Because once the company Aircel comes into CIRP, the problem arises. Now, obviously, that decision of DOT was also challenged before TDSAT, but TDSAT said, sorry, you have to furnish those bank guarantees. So, of course, this was challenged to higher authorities. Later, this was reversed also, but at that particular point of time, they were required to furnish the bank guarantees. Now, Aircel did not have the money. So they requested Airtel that why can't you submit the bank guarantees? So because you have the money, in any case, you have to pay a certain amount. And the agreement was that the payment which Airtel is supposed to make over a period of time, of course, it was 4,022 crores for use of those spectrums, 8 agreements. So they say you can adjust that amount from of bank guarantees from this particular amount. Whatever you are paying in installments, then probably those can be adjusted. So bank guarantees were roughly in the range of 400 crores, 400 odd crores of rupees. So Airtel, and later on, Aircel, once they became rich in the sense that they got some money, they said, okay, we will replace the bank guarantees. And Airtel now was supposed to pay the amount which was deducted because they were deducting the amount. So naturally, when you replace the bank guarantee, so Airtel gets its money back. So now the money which they have deducted from Aircel, they were supposed to pay it back. So that was the amount, right? So here, Airtel actually paid some amount, and they said, look, balance amount is set off because Aircel also owed a certain money to Airtel. Now, what was the money which was owed? This was on account of some operational charges or SMS charges or interconnection usage charges. Those kind of arrangements were there. So here, let us understand, Airtel was paying the rental for the spectrum, and you see reverse, the Aircel was also supposed to pay some amounts which were relating to these because they were being charged. So naturally, the spectrum owner has to be at that. So Airtel was to recover certain amounts. So they set off that particular amount, right? And that setting off actually caused a problem. Now here comes the problem. The Aircel company came into CIRP on 12th March, and the other company, Dishnet, that came into CIRP on 19th March. So here, my dear friends, please remember, and there is the Supreme Court says so in their own judgment. And that's a very important statement which we'll not forget. The nature and character of a company changes the moment the company comes into CIRP. Please remember these words. The nature and character of the CD changes the moment the company comes into CIRP. Anyway, I'll explain what does that mean, because I was also trying to understand how that changes, and it has been explained in this judgment. So now Airtel, now once the company comes into CIRP, so Airtel filed certain claims because they were supposed to get certain amount from on account of running these kind of expenses, network charges, SMS charges. So some outstandings were there from Aircel. So they charged, they filed a claim, a higher claim, but RP admitted the claims up to 112 crores. So he said, okay, I will admit only to the extent of 112 crores. Then RP noted that Airtel had adjusted 112 crores because of the bank guarantees amount, right? The balance amount. So RP, once he took over, now he sent an email asking Airtel that said, look, you pay now. Because you have set them off on a suo moto basis. There was no kind of an agreement for setting off. So therefore, you have to really pay back that amount. So Airtel continued to claim that amount as set off, and they did not pay to the RP. And RP naturally rejected the claim for set off. They said, sorry, but you will have to pay. And naturally, if Airtel is not paying, what the RP of Aircel can do? Now he approached NCLT and saying that, look, Airtel does not have a right of set off. So please ask them to pay. But NCLT unfortunately said Airtel has a right of set off. And they rejected the argument of the NCLAT, of the RP. Now, RP went into an appeal, and NCLAT overturned the order of NCLT, saying that as far as the set-off is concerned, yes, that set-off is possible. Now, no, sorry, that set-off is not possible because a set-off was allowed by NCLT. NCLAT said set-off is not allowed, right? It is not possible. And these are the three arguments which were given by NCLAT, reasoning which was given by NCLAT. They said, look, number one, the set-off violates the basic principles and protection under any insolvency law because there is a moratorium. Two, set-off is antithetical to the objective of the IBC. They say it is not permitted under IBC. And they also referred section 238, right? With 238, we all know there is a non-obstant clause which says that IBC will supersede all other provisions of law if there is inconsistency. They also relied on section 14 moratorium. And then they said set-off was also claimed. Now, this was also an important point. They say set-off has been claimed in two separate and unrelated transactions. They say the transaction of rental on the rental payment on the spectrum charges, and then the adjustment on account of bank guarantee. There are two separate transactions. They're nothing to do with each other. So therefore, they cannot be set off. So these were the five logics which were given, reasonings which was given by the NCLAT. Now the question before the Supreme Court and for all of us, my dear friends, is this. Can a set-off right is available to creditor in CIRP process? Now, the situation may be different in personal insolvency or personal bankruptcy and liquidation. But here the question is whether in CIRP this is permissible or not. Now, friends, before I move forward, I think let's have certain examples of the set-offs, how the set-offs can be claimed. CD is supplying certain items to, say, vendor A, or I mean, this company B. Now, that company B in turn is also rendering some services to CD. So therefore, now you have a two-way transactions, right? So transactions between A and B, and then B and A. So money is naturally, they both are debtors and creditors in this in their own right. Maybe interlinked transaction, may be separate. Now, how can there be a single transaction, or in the same transaction? Let us look at that. Number one, if a customer pays an advance, say he pays an advance of 2 crore rupees for manufacture of a customized machinery, and naturally the CD will ask for that money, or any manufacturer will ask for that, because they are trying to manufacture a customized machine for you. So they take an advance of 2 crores. Machine is built, machine is supplied, machine is built for, say, 5 crore of rupees. So now CD has to take 5 crores because that is a bill, but there is a 2 crore advance which is lying. So it can be construed as a part of the same transaction, because it was for purchase of the machinery. There was a amount which was given as an advance, and then probably it needs adjustment against that. So this is the second situation of a set-off. The third situation of a set-off is similar. Like CD takes up premises on rent. Naturally, they pay security deposit, they pay advance rent, right? And then some rentals are also due. So can those rentals be adjusted against those security deposit which is lying with the landowner? That could be the third case. So there can be n number of circumstances, my dear friends, or company has given certain amount to the directors for expenses, right? And the directors have given loan to the company. Now, once the company comes into CIRP, so what should be the criteria? Because as far as the loans are concerned by the directors, they will naturally file the claim. But can they file the claim by setting off the amount which has been paid to them? Or the company can say, look, we have already paid you. I will recognize your claim only to this extent because I have already paid you. So there can be a number of circumstances, my dear friends, under CIRP. I don't know how the RPs have been treating it right now, but here is a case where the Supreme Court has come into play, where the circumstances they wanted to decide that what should be the criteria for the set-off, whether set-off is permissible or not. That's the bigger question, right? More than anything else, whether set-off is possible in CIRP or not. Now, the judgment talks about, in a very, very interesting manner, it talks about that there are 5 kinds of set-off. He says, before I come to the conclusion whether set-off is possible in CIRP or not, let us educate the public and let us try to, bring out that what kind of set-offs are possible. So the judge says that in the judgment, it is mentioned that number 1 is the statutory or a legal set-off. Second could be common law set-off. Third could be equitable set-off. Common law and equitable, he has actually recognized as one in a later part of the judgment. And then there could be a contractual set-off. Whether set-off is possible or not, but both of us agree to set-off. So that is also contractual. And lastly, it has been categorized as insolvency set-off. My dear friends, please remember this word. Insolvency set-off is a word which we have to remember and we have to apply whether it is possible in CIRP or not. Because please remember, the nature and character of the CD changes. That is why we are not talking about contractual set-off. We're not talking about anything. We are talking about insolvency set-off because the company is under insolvency now. The situation may be different if the company is not in insolvency. But the moment it comes into insolvency, the Supreme Court in this judgment says the nature and character changes. First of all, then, of course, let us also understand what is meant by contractual set-off. Naturally, it is a matter of agreement between the two parties. If A and B agree to set off, whether unrelated transactions, related transactions, or whether same transaction, different transaction, both the parties agree, it can be done. I owe you 5,000 rupees, you owe me 2,000 rupees. We can agree that, okay, we'll settle at 3,000. That's fine. And there may be 2 different transactions. Parties are free to mutually agree. But the only point is that agreement should be valid, binding, and not against the public policy. policy, right? We can't adjust, you see, illegal activities, payment against the legal activity. So it should be, again, not against the public policy. So naturally, the terms of the agreement have to be seen. The second set off which the judge mentioned was statutory or legal set off. So it says it is created by a statute. The statute gives a right of a set off. And he also brought in to notice Order 8, Rule 6 of CPC. Now, under CPC, whenever a person files a suit, the other party, the defendant, can file a reply that, look, this money is not owed. But then they are also entitled to file either a counterclaim also and a set off. So counterclaim is also a recognized principle under the law. So which means that there are cross claims between the same parties in the same right. But this is very, very important. So claims should be ascertainable. They must be legally recoverable. So if they are barred by time, naturally, no set off is possible. So cross claims between the same parties in the same right? And friends, please remember, in contractual set off, if I agree, even time bar debts can be adjusted because it is a matter of a contract. So therefore, nobody is prohibiting in that way. But in case of a statutory or a legal set off, naturally, it has to be legally recoverable. That is also important. The third is common law or equitable set off. Like it is like supposing you give a job to a contractor. He does not perform in a timely basis. He is delaying the project. And then in the agreement, it is mentioned that he will pay, you will be entitled for unliquidated damages. So there can be liquidated damages, which you say 3,000 rupees per day. So now it is ascertainable. But there can be unliquidated damages, which is unasserted. These are generally allowed by the courts. No, you may claim any amount, but ultimately it is for the courts to allow that. So it can be equitable set off is like it's to adjust the equity. So an ascertained or ascertained sum, and there can be a collection between there must be a connection between the claim and a set off. That is very important, right? And they must be arising out of the same transaction. So equitable set off is always considered that they should be considered as one transaction, same transaction. It can't be that you can adjust on a different set off. Now, coming to insolvency set off, my dear friends, insolvency set off is not defined in India. But there is some portion of it in our IBC also. I will share it with you, but let's first of all understand. In UK law, insolvency set off is permitted if there are, please remember these three words now: mutual debts, mutual credits, and other mutual dealings. So UK law says the moment you are able to demonstrate that is a mutual debt owed, mutual credit owed, or a mutual dealing between the same parties during a relevant cutoff time. And as far as the cutoff time is concerned, the judge also says in this judgment that relevant cutoff time, insofar as IBC is concerned, I will treat it as ICD. So remember that. So insolvency set off is equal to be seen at the insolvency commencement date, because the nature and the character of the company changes. This is what he says, right? Now, there is one more situation. Under the CIRP and liquidation, these are the two processes. And similarly, we have a process of bankruptcy of individuals. Now, my friends will recall that Regulation 29 of the liquidation regulations, it permits set off. This particular regulation is missing in CIRP regulations, right? And similarly, Section 173, which falls in Part 3, which relates to bankruptcy of individuals or partnership firms, that section also permits set off. So two sections in IBC also permit set off, but they are in liquidation and bankruptcy, not in CIRP, not in insolvency or personal insolvency. Now, this is Regulation 29. I'm just reproduced for your benefit. Look at what our own regulations say. Mutual credits and set off. Where there are mutual dealings between the corporate debtor and another party, the sums due from one party shall be set off against the sums due from the other to arrive at the net amount payable to the corporate debtor or to the other party. And if you look at regulation, they have given an illustration that if a company owes 4,000 rupees and it is to receive 5,000, then it can, if it receives only 1,000, it is fine. So mutual credits and set off, my dear friends, without any restriction, without any prohibition, without any condition, is permissible in liquidation. They may or may not be out of the same transaction. They may or may not be they may be out of separate and distinct transaction. That is all right. So this is what the section regulation 29 says. Now let us look at section 173. 173 again, it says where before the bankruptcy commencement date, they are talking about BCD now, there have been mutual dealing between the bankrupt and the creditor, then the bankruptcy trustee shall take into account what is due from each party to the other in respect of mutual dealings, and the sum due from one party shall be set off against the sum due to the other. And only the balance shall be provable as a bankruptcy debt or the amount payable to the bankruptcy trustee. So even if the person becomes a comes into bankruptcy, the bankruptcy trustee is entitled to adjust the amounts. Whether receivable or payable will be determined only after adjusting the two accounts. So mutual dealings, whether on the same account or not account, like director has given a loan, on the other hand, company has given money for some advance for expenses or advance against salary, they can be adjusted. So net amount will be either receivable or payable. So I hope I'm clear on this. So insofar as liquidation is concerned, my dear friends, and bankruptcy is concerned, they deal on a different footing, but this section and that regulation is missing in CIRP. So regulation 29, the Supreme Court also says, is not applicable to CIRP. So somebody can argue, oh, regulation 29 is there in liquidation, why can't we apply to CIRP? Supreme Court says, sorry, it can't be done. And what they are saying is that in regulation 29, the Indian law uses the term mutual dealings. Mutual dealings, that is the key here. So they have explained what is the meaning of mutual dealing, and let's understand, because here I'm not only talking about CIRP, my dear friends. Your companies may be in liquidation. If they are in liquidation, you need to understand the meaning of the term mutual dealings. They say it is wider than the statutory set-off and equitable set-off. And there are demands between the same parties. They are talking about only demands. Demands on what account, on what transaction, not relevant. Not relevant. Mutuality can exist when there are several distinct and independent transactions. So even if there are independent transactions, they say mutuality can also exist. The next sentence is very important, friends, and please underline that. Mutual dealings are not concerned with the nature of claim. They are only concerned with relationship. A and B, that's all. A owes money to B, B owes money to A, end of story. We have to just see that same relationship. Now, it can't be that A owes money to subsidiary of B and then B can be adjusted. The answer is no, because that is not a mutual dealing. Parties should be same. That's all. It is a relationship which matters between the parties. The nature of the transaction, the nature of the claim does not matter insofar as liquidation and bankruptcy is concerned. I hope I'm clear on these two aspects, because now we are getting a learning even in those kind of things. So nature, and this is what he also stated, that the nature and identity of CD undergoes a change on the commencement of the CIRP. Now, coming to mutual dealings in CIRP, the judge says the moment the company comes into CIRP, the nature and identity changes, so they are not the same parties. This is the logic behind it. That why mutual dealings are not permitted during this, CIRP. So it says, therefore, the set-off of dues payable by CD for a period prior to CIRP cannot be adjusted from dues payable to CD post the commencement of CIRP. This is a very important sentence, friends. So prior to CIRP and post the CIRP, the adjustments cannot be made. But if the parties have already contracted and they want to adjust prior to CIRP, well, that is possible. So therefore, that is an exception which has been given. Now, let us come down to another aspect, insolvency set-off. Insolvency set-off, which means that a company is in insolvency, whether set-off is possible or not. One of the argument is that insolvency set-off mitigates against the pari passu principle. And when cross demands are set off, the assets available for distribution also gets depleted. So therefore, they say that it should not be possible. Insolvency set off should be allowed when mandated or can be justified by law. So mutual dealings, now he's dealing with that look, if it is mandated by law. Now it is mandated by law in Regulation 29. It is mandated by law in Section 173, but in CIRP it is not. And there is another example of that, principle of anti-deprivation. Now, what does that mean? And they have given an example. Just I'll show you the next screen and please read this. I think then the things will be clear. A person enters into a contract which says that this property will remain my property till the time I go in bankruptcy. The day I go in bankruptcy, this property will belong to you. Is such a contract valid? The Supreme Court says such a contract is not valid because this is against the principle. This is known as the principle of anti-deprivation. You are depriving the creditors because the moment you go into bankruptcy, you are saying that, look, these assets will not belong to me. So then what is the point? So therefore, such types of contracts are not valid, right? Now, Regulation 29 cannot be applied to CIRP, which we have already seen. But they say basic principle is the Regulation 29 does not apply, but it can still apply. Under what situation? They say if the party is entitled to a contractual set-off on the date which is effective before or on the date of the CIRP is put to in motion or commences. So if the parties have entered into an agreement prior to CIRP for a understanding and that has been effective before that date, then it is possible to have a adjustment of set-off, right? So it is pre-CIRP, not post-CIRP. And then CIRP commencement does not change the terms of the contract. Now here they are also, why they are relying on this, saying this, they said, look, if you enter into a contract prior to CIRP, the moment the company comes into CIRP, will that contract be remaining same or not? Whether the companies will be bound by that contract or not? They say answer is yes. Because the nature of the contract or the terms of the contract does not undergo a change. And RP cannot change the terms of the contract. So therefore they say that, look, contractual set-off, which is entered or made effective before the CIRP date, now the adjustment can be done. So this is the first exception. The second exception is they are talking about the equitable set-off, right? They say if in equity, it is still possible if both the set-off are linked and connected on account of one or more transactions that can be treated as one. Like I gave you an example, the person gave money for manufacturing of machinery and the company supplies machinery. I think they can be treated as one transaction. You hire a contractor, you pay an advance. Now, he was supposed to construct a building for the CD. He does not do that, but he has brought in some cement or say some cement and he has raised a bill for cement because he says, okay, I've supplied cement to you, I'm raising a bill. So bill for cement and the amount which is paid, probably they can be adjusted because they are part of the same transaction. So this is what the Supreme Court says. So genuine claims, if they are not set off, what is the logic? They say if they are genuine claims which are not set off, now it will be unequitable and unfair to ask money from the debtor. So that is what they say that, look, this is possible. But then they have cautioned that set off can be against money alone and not against assets. So assets, it can't be adjusted against the asset. It can be adjusted against the money. So the bill raised for the cement and the amount paid to the contractor as advance can be adjusted. But supposing he has only dropped cement there. Now cement cannot be adjusted against the amount because cement is not the money. It is an asset which is there. So therefore they say it can be adjusted only against money alone and not against assets. Now they are terming it as transactional set-off. So remember, my dear friends, in CIRP, two types of set-offs are permissible. One is contractual set-off, which is effective prior to CIRP date. And second, if it is a transactional set-off. That means it is arising out of the same transaction between the same rights and the same parties. These are the three conditions which you must bear in mind. So that is what they say in CIRP also, it is permitted. And but there should be a complete connection between the parties. And the transactions must be completely connected. So if they are not connected, naturally, everything will depend upon the facts of each case, right? And then they also say that it does not contradict the moratorium. That is also possible. So here in this case, ma'am, just wait. I'll just finish and then we'll take questions, right? Just give me 2 minutes. So insolvency set-off is neither automatic and nor self-executing. They say it is not automatic. Somebody has to apply its mind. RP has to apply its mind. Somebody has to argue a case that, look, they are between the same parties, they are transactional set-off or they are a contractual set-off. So self-execution is not possible. That, look, I owe you money, you owe me money, therefore I'm adjusting. That is not possible. The adjustments are to be based on the contractual set-off, and they can also be grounds for equitable set-off. So here they say that in the case at hand, the set-off was allowed and permitted by the RP to a certain extent, but others he did not allow, and he asked for money for 112 crores. The court says, now that is not possible. Please pay back 112 crores. So they have gone into the facts of the case. They say, look, the bank guarantees were returned. So Airtel got its money back. So therefore, it is a separate transaction. It is an unconnected transaction from the spectrum contract or the use of the spectrum. So therefore, they directed Airtel that Airtel should bring money back to the company, to the CD. So this is what you see is all about. I'm just leaving it here right now. If you have any questions on this, I know it has become a little complicated because it's a new subject, more theoretical, but still, I think we can really understand the concept. Now, yes, please, if you have any questions, let me know.
Sir.
Yeah.
Good evening, sir. Thank you
good
for
evening.
such a
Good
wonderful
evening. Yeah.
presentation. Sir,
Yeah.
every time we think we have clarity, then we get confused again. So that's how these questions are getting raised. See,
Right.
at one point of time, we say that any payment which is done during CIRP to a person will amount to preferential payment if it does not fall under any of the services which are against any of the services which are taken during CIRP. So in this case, when we say set off, like, I owe you 100 rupees, you owe me 50 rupees. So technically, I am paying you back that 50 rupees, right? Though it is called a set off. So wouldn't this amount to a preferential payment?
See, there are two things. What is preferential payment? Preferential payment is 1 year or 2 years prior to CIRP. Here, that is not the case. Here the case is that it is, see, because in preferential transaction also, now we have to satisfy 4 conditions, right? It is not a simple, what is a preference? What is a deemed preference? The deemed preference is that there should be you see amount which is paid against a transfer of property against an antecedent financial debt. So if a director has given a loan, there is no antecedent financial debt. So therefore, there is no question of preferential transaction. So therefore, you have to see this. Supposing the company has given money for this thing and that is adjusted. So I don't think it will fall under preferential transaction. Because our preferential transaction, you have to satisfy those conditions which are mentioned in the section 43, subsection 2. Now, there is another thing. Exceptions are given in 43.3. Because, and what is the first exception? Remember that ordinary course of business. If the transaction is in the ordinary course of business. Now, if it is in ordinary course of business and this see, if you are setting it off contractually, you have entered into a contract, it can be a part of ordinary course of business. Of course, Supreme Court says, please apply your mind. It is not a case simpliciter that you see A owes money, B owes money, end of story, you can adjust. No. They say RP will have to go to the facts of the case. If the facts of the case justify that, look, it is not there, so therefore you will see whether it is preferential or not. That is, of course, your duty. So regardless of that, if it is not, then naturally you can see that, oh, they entered into a contract. And even that is also another question. Because what we have seen, Mr. Sharma is there. In his case also, he is now getting, you see, claims from the certain creditors where the document has been signed just 1 month before the CRP started by the directors. And we feel that agreement is a fraudulent agreement because he signed under a pressure, right? So therefore, we are saying that these agreements are not binding on the company. So you will have to see and demonstrate that, look, these are binding agreements. These are legal documents. only then the adjustment is possible. If you still feel that the directors have committed some kind of a fraud by signing such an agreement, you will not adjust it. So the onus is on the RP. Court is giving you only 2 exceptions, but those exceptions, the facts and circumstances, it will depend upon that. So that is the answer which I can give you. Okay.
Sir, in this case where you referred Sharma sir's case,
Right.
now suppose see what happens is once we file the application in the NCLT, by the time it gets approved or admitted under section 7 or 9, there is a considerable time elapse.
Right.
Okay. So suppose if the director comes to know, or he would know that it has been pending under NCLT. So can he execute like, suppose 9 months are lapsed from the time the admission, from the time of application to admission. Now, suppose the contract was signed, say 1 month before this. So how do we consider that?
Well, typically such kind of a contracts, which you can always presume that, look, if they are satisfying the conditions of preferential, undervalued or fraudulent, you will naturally deal with them and they will not be treated as a set-off. So naturally there, the application of mind by the RP has to be there. It is not a case simpliciter. See, in case of liquidation, there is a problem. Of course, if it is a case of fraud, liquidator can still say, I will not allowing set-off. But otherwise, in case of liquidation, if there are mutual dealings, we have to just see the relationship of the party. Nothing to do with the contract, nothing to do with the type of the transaction. You have to allow mutual dealings, right? But because the statute permits it. But still you will apply your mind even in that case. Supposing it is a fraudulent transaction, then naturally you will not allow set-off even in liquidation. You can refuse that also. That is the thing which I think we'll have to deal with this. So we are coming to now, what I say is advanced learning nowadays, isn't it? So, but this set-off in CIRP was a very welcome judgment in the sense that we had a gap, we had a vacuum. Because how to adjust, whether to adjust or not. I don't know how RPs are handling it. Supposing you owe to the person, say 20 lakh of rupees and the person is claiming 50 lakhs. Now, how do you only admit a claim of 30, or you say you pay me 20, I will admit your 50 because आपके 20 आएंगे तभी मेरा काम चलेगा. So I think those kind of things we've seen. Yes.
Only one question, sir.
Yeah.
So utility supplying company is there. Normally CD keeps some security deposit with the utility company. He separates some utilities.
Which company, sir?
And some electricity department.
Electricity department, yes.
Suppose then after the commencement of insolvency or commencement of liquidation, he does not lodge a claim for the supplies charges for that while returning the security deposit without lodging the claims. Is it allowable?
See, the point is, as far as the electricity, we were discussing about the claims just now.
Yes.
The claims cannot be admitted by the RP unless they are filed.
Yes.
In a form, right? Proper form. Of course, the Supreme Court says whether it is form number 1 or 2, it doesn't matter. The point is, it has to be filed in a form.
Yes, sir.
If it is not filed in a form, then of course it will not be treated as a claim and RP will not be in a position to verify that, right?
Yes, sir.
Electricity department naturally has to file a claim.
Yes, sir.
And on the other hand, if a security deposit has been given, so that security deposit, if the electricity connection is going on, there is no question of asking for that security deposit. But if your connection is disbarred, disconnected, you don't want that connection, naturally the company is entitled to have a refund of that security deposit. But electricity department will not do it because they have got dues. So you can tell them that, look, you file a claim.
Okay.
Only then I'll consider. Till the time you don't file a claim, sorry, I cannot consider anything about it.
Okay, sir. Thank you, sir.
Okay. So any other question, friends, on the adjustment of set-off of the claims under the CIRP? Okay. Okay. So this is a good judgment, friends, which we need to really look into this.
We can exhibit Form C under Section 7 or CIRP.
That's all right. It is
Column 8 of Form C casts the responsibility on the claimant that he must also declare what are the set of transactions. If somebody can show you on screen the Form C under CIRP.
No,
You
that
would
is
see
okay,
that
no, Mr. Sharma, that is all right. We all know that there is a form in which that column is there, but
in the
as
CIRP process.
in the CIRP process, see, number one, when CIRP is not permitted in a set off, there is no question of asking such an information. The information why it is sought, I can think of one reasoning. One reasoning is that, look, that means he is going to disclose what are the other transactions with the corporate data. So naturally, as an RP, you will get more information. So probably it is more for an information rather than an adjustment in this case. Because Supreme Court says it is not allowed except under two circumstances: contractual set off or maybe a transactional set off. If it is a
And we
part
have
of
to
the
be
same
careful, sir. People just put a dash in column 8.
So that is the problem now, because you see, on the one hand, they are asking for the money. And now if they are trying to set off means the money owed by them to the CD. Nobody is going to disclose that. Who is going to disclose that? That means if you disclose that, then you're admitting liability. So therefore, this form is actually not very beneficial insofar as the creditors are concerned, the claimants are concerned. So that is there. Yes. So I think, Mr. Manoj, Mr. Anand, I think we are now left with very little time. I think we have already overshot the time. So maybe I wanted to take another judgment, but I believe the time is pretty short. We should leave it at it is now. So, or any questions are there from the audience, I think we can take up those.
Yeah, Mr. Mukhija, if you feel comfortable of taking that judgment, you can take it. We can extend our timing to another, say, 15, 20 minutes or something like that, if you are comfortable.
I mean, it's going to take 15, 20 minutes. So that is why I was wondering if everyone is okay with that, then I can take it.
सर आपको सुनने के लिए सब तैयार रहेंगे, पूछने की जरूरत ही नहीं है. Please carry on.
I want, because that people leaving and then there's no point in speaking there. So that was the idea. If everyone wants it, probably we can do that, right? Okay. I think we are
Please
getting
go ahead,
it.
sir.
Okay.
I'm okay with it.
Please continue, sir.
Okay. So let us take up that. Okay. So this is the next judgment, which is very important judgment, and it also gives a very important issue which has been dealt with, which is DBS Bank Limited, Singapore versus Ruchi Soya Industries. And this is this judgment came not very far. You see, it was of 6th of December. Let us try to understand the facts of the case first. DBS Bank had extended a financial debt of almost around 243 crores, which was equivalent to $50 million to the corporate debtor, which was Ruchi Soya, right? That was, and their debt was also secured. They had a sole charge. They had got a first charge over few immovable properties and fixed assets of the corporate debtor. So they had a exclusive charge. And then CIRP, the Ruchi Soya came into CIRP on 15/12. RP admitted the claim of DBS to the extent of almost around 243 crores. So that is the same amount. Now, these are the few dates which are very important. 15th March 2019, Patanjali submitted a plan for payment of around 4,134 crores. And total claims were 8,398 crores. So they proposed typically a haircut of 50.78%. Now, DBS, when they saw that plan, and they wrote that, look, they wrote to the COC that, look, the liquidation value of the security interest which is with me is greater than others. So therefore, while you decide the distribution of that amount of 4,134 crores, now you must take into account the security interest, the value of liquidation value of the security interest, right? They mentioned that. The COC ultimately rejected. They said, sorry, we are going to distribute the amount pari passu. That means whatever money has come, all secured financial creditors will get the money in pro rata basis, regardless of the security interest. You may have a better security interest than others. We don't care. So naturally, and the plan was approved by 96.95%. DBS was not satisfied with pari passu distribution. So only question here is distribution. We're not talking about any other thing here. So DBS voted against the resolution plan. So in accordance with section 32B, naturally they became entitled for that benefit of the minimum amount. Now, they also filed an application before the adjudicating authority saying that we are challenging the distribution mechanism. Now, adjudicating authority rejected DBS application. Now, appeal was filed against this order by DBS before the NCLAT. That was on 31st of July. On 16th August, my dear friend, now this is a very important date. Look at this. While the appeal was pending, the act was amended. 32B clause number 2, it was amended, which guaranteed minimum value to operational creditors and financial creditors who have voted against the plan, right? And there was another amendment, my dear friends, under section 32, there was an explanation which was added that this will also apply to pending proceedings. This was very interesting. And subsection 34 also was amended and said COC shall take into account the order of priority amongst creditors. So now here the plan is approved by the COC. It has also been, I don't know, something is mentioned. It was provisionally approved by adjudicating authority. I don't know what is the meaning of that provisional approval, but anyhow, that is one part of it. So DBS asked COC to consider in view of amendment, but COC rejected on the ground that appeal is pending. Because of this amendment, DBS again went back to COC. COC says, sorry, nothing doing. Matter is sub judice. Let that be decided. So NCLT approved the plan on 4th September 2019. So NCLT approved it, right, after this amendment. And then again, second appeal was filed before, against the approval of the plan now. Now NCLT, there are two appeals which are pending with NCLAT. So NCLAT dismissed first appeal, which challenged the distribution mechanism, and also it dismissed the second appeal, which challenged the approval of the resolution plan. So now both the matters went to the Supreme Court. So now we are dealing with the Supreme Court. So Supreme Court has to decide now, this is the question, whether section 32B2 of the code entitles the dissenting financial creditor to be paid the minimum value of its security interest, whether they have to be paid pari passu or whether they are entitled up to their security interest. That is the big question which is there. Now, ultimately, let us look at the facts. The liquidation value of the security interest was 217 crores. Naturally, their claim was 243 crores. So they can be paid maximum up to 218 crores because that's the LV. But pro rata distribution entitled them now 119 crores. So they said we are at loss by 99 crores. So naturally, they went up to Supreme Court. So the difference was not small. It was 100 crores. So then the Supreme Court says that a change in the law can be applied to the original or appellate proceedings. Wonderful. And they say explanation 2 is constitutionally valid. And despite having retrospective operation, it does not impair the vested right. So that is what they are saying, that even that can also be applied. Then they relied upon 3 judgments, Swiss Ribbons, SR Steel, and another Shiva Industries judgment on the fact of the commercial wisdom of the COC must be respected. I think we already know this. They say COC can decide the manner of distribution of the resolution process, proceeds amongst the creditors and others. They say we recognize that right. But they say that right is subject to 32B. 32B, they say it protects the dissenting financial creditor and it ensures that a minimum value which is equivalent to the security or the liquidation value must be paid. So liquidation value of the security interest. So that is the main whole plan there. So, and then he says that, look, because here a secured creditor is unwillingly giving up his security. In the resolution plan, there is no willingness. He's giving it unwillingly, right? So therefore, he must be entitled to the valuation, to the value of the security as payable on the liquidation of the corporate debtor. So somebody relied upon that India Resurgence judgment, that is Amit Metallics, right? That was quoted, in which this was the law. They said, look, the money which is coming in the resolution plan, it has to be distributed on pro rata basis. You can't say that I will get a higher money than other financial creditor. He says, no, section 53(1) says pro rata. So that pro rata, you see, I'm applying even in the CIRP because Section 32B refers to 53 and 53(1) talks about pari passu. So therefore it should be distributed. So that was the logic in Amit Metallic's case. But this bench actually differed with that view. They say, sorry, we are not agreeing to that because pari passu, they say, is not mentioned in 53(1). It is mentioned later. It is mentioned in 53, but not in 53(1). So they say, and 32B only refers to 53(1). Now that is a catch which they have taken. Please understand this. The pari passu word is not mentioned in 53(1). It is mentioned later in 53. But they say in 32B, the reference is only to 53(1), and they are not simply saying section 53. It says 53 subsection 1. So therefore they say that it will be inept. So they say it is incorrect to state that the dissenting financial creditor would not be entitled to receive the liquidation value, the amount payable to him in terms of section 53(1) of the code. And if that is not done, then the plan cannot be accepted. In fact, it will be the duty of the RP to point out that, look, this is not compliant to the provisions of section 32B. So they say what is entitled to the security interest, the dissenting financial creditor is entitled to be paid to that amount, right? So this is what they have stated in 2-3 paragraphs also. So friends, here is the whole catch. And this is the important sentence which I would just like to read. Section 53(1) is referred to in section 32B2 for the purpose and objective that the dissenting financial creditor is not denied the amount of the payable which is payable to it being equal to the amount of value of security interest. The entire section 53 is not made applicable. This is what they are saying. They say, well, I will read only 53(1). Why should I read the entire 53? If that was the case, the legislature should have mentioned 53. They say they are only referring to this. So here they say, as we are taking a different view and ratio from India Resurgence on interpretation of 32B2, therefore we feel it would be appropriate if the question framed at the beginning of the judgment is referred to a larger bench and the matter be accordingly placed before the Honorable Chief Justice for appropriate order. So friends, if you are simply relying on India Resurgence versus Amit Metallics, those days are gone. So we'll have to wait for that, because now there is a contradictory judgment by a similar strength of bench. Naturally, it has to go to a larger bench, to a higher bench now. So we'll have to wait for that time. And till that time, you have to really apply 32B in terms of section 53 and not a pro rata basis, but payment of the liquidation value. Okay. So this was again a very interesting judgment, friends. Okay. So I think
Sir, here one question.
Yes, sir.
It has an RP between the time the retrospective amendment came and the plan approval.
Right.
If you read retrospective amendment, that shows that the plan was not compliant with the code. So RP.
The argument was, please understand, in section 32B2, it was mentioned in an explanation that it will take effect from even for the pending proceedings. But unfortunately, section 30 subsection 4, which was amended, right? It was not amended retrospectively. There it said that the COC must look at the value of the security interest, right? May take into consideration the value of security interest. Now, this amendment was not made effective on pending this thing. So the argument was that 34 does not apply retrospectively. So COC is not bound to take into it, because there was a contradiction between two sections there. But Supreme Court says nothing doing. We will read as one harmonious reading. And therefore 32B applies even for the pending proceedings. And typically in this case, because they say the matter was pending before NCLAT. So NCLAT could have applied that formula. So that was the whole thing. Okay, but anyway, it's a good point which you have raised. So friends, any more questions? If there are...
Good evening, sir.
Yeah, good evening.
Sir, this side is CA Trisha. Actually, I have recently taken up to study on Insolvency Act.
Okay.
And it's just been 4-5 days I have been studying, and I'm feeling a pressure that the course is so much, and every day I just able to read for 1 or 2 pages. So kind of a fear is being getting built. I am not sure how to carry out the study.
Okay.
I'm
Trisha ji, isme, what I can do is, I mean, this is not a forum, proper forum to discuss all these things, but yes, definitely, sometimes people get overwhelmed with such kind of a syllabus, and particularly as of today, the case studies are actually 75%. So unless you know the law, you know the case laws, and you know how to apply the law, is very difficult to pass, right? The people who have already passed the exam, probably at that time, the syllabus was little nominal, more theoretical. They passed it very easily, right? I'm not saying, I'm not undermining their efforts, but that was the fact of the case. But today, naturally, the volume, the syllabus has gone up. So what you can do is, maybe I will leave my number. You can talk to me offline, and
Yeah.
I will be definitely be helpful. I mean, will be able to guide you on this, right?
And sir, can you just tell us that how much time frame we should take in our front? Like 15 days is not sufficient, 2 months, or what is the time frame for it?
Broadly, you must keep a study in mind that you have to study for minimum 100 to 120 hours.
20 hours, 120 hours.
If you are spending, say, 4 hours a day, so 30 days minimum, right? Don't take the exam unless you study that carefully. And you have to do stop, look, and go. You have to make
Those
stop, look, and go, right? That's the formula you should remember. You have to read the act 3 times,
3 times.
right? Till the time because if you don't meet a person 3 times, you don't remember the name of the opposite of the party, right? Or you don't know him particularly. So therefore, I've given my phone number.
Yeah.
And the box you
Can I also note down your number, sir?
I've already
It's
given
in
it.
the
Okay, you
yeah
have given
chat
it.
box,
Okay,
chat box,
okay,
chat
okay.
box.
Thank you, sir.
Yeah, and in any case, yes, Neeraj Jha is saying, because typically we are holding certain kind of master classes, but they are not meant for the freshers. They are meant for the IPs. But yes, there is another program which is known as Sure Shot IP, where Manoj also mentioned in the beginning that I also take training for the people who are aspiring to be IPs. Maybe we can help you on that. Okay.
Thank you, sir.
I never thought of that. Aspiring IPs be also coming in our program, because our program is generally meant and being circulated among practicing IPs. That's really a good, something very good. Sir, आपका नाम देखो कितना, not
This
only
shows,
practicing but aspiring also come, seeing your name in the webinar.
this shows the dedication actually. So dedication is
We saw it from the YouTube only.
There is one question.
I want to tell that an architect was wanting to be IP, and that architect was talking to Mukhija sir 3 days ago.
There is one question.
Yes, please carry on.
Yes, sir,
Myself,
please.
Mahendra Jindal. I am chartered accountant and IP.
Yes, sir.
You mentioned that in section 32B2, the
Right,
mention of subsection 1 of section 53,
right,
not the entire section 53.
right,
But this pari passu distribution is in
right.
explanation. Explanation 1 says that the pari passu distribution in all the section will be made. So it will not applicable to 53(1).
No, that is all right. But at the end of the day, see, the point is, the court has looked into section 53(1), right?
Right.
There they say that 53 subsection 1 does not talk about pari passu. So therefore, they have said that, look, if we look at that particular this thing, so it only talks about ranking equally, and that is all. So, and pari passu, if you look at, that is given in later part. So that is what they are saying, that is the harmonious construction, because see, there is a conflict in the sections, so therefore they have come to that particular view that, look, if we look at section 32B, it only talks about, 53(1). So they have basically relied upon that.
But sir, explanation will be applicable on all the subsections 1, 2, 3, 4.
No, see, that is all right. That is all right. Explanation is because this explanation is given under 2 only, na?
Explanation 1, 53, after subsection 3, explanation 1.
It does not say, sir, pari passu, na? Please read. Where are the words pari passu written?
It is hereby clarified that each stage of the distribution of proceeds in respect of class of recipient that rank equally, each of the debt will either be paid in full or will be paid in equal proportion within the same class of recipient. if the proceeds are insufficient to meet the debt in full end. This is the
you're talking about 53 only or 32B.
explanation 1. 53 explanation 1.
Right. Okay. No, no. Please look at no. Because you see, it is mentioned there underneath that it is hereby clarified that the distribution of proceeds in respect of recipient that rank equally, each of the debts should be paid in equal proportion if the proceeds are insufficient to meet in debt. Yeah.
So if the secured creditor are getting less than their security who has approved the resolution plan,
right,
the person who is dissenting the resolution plan will get.
No, even if this is also taken, because that was one logic. The second is they say that look, 32B protects the person for me getting some minimum value. अगर आपको देखिए, अगर आपको proportionality देना है, तो आप 32B का मीनिंग क्या रह गया? आप मुझे वो सुप्रीम कोर्ट कहता है बताइए फिर क्वेश्चन क्या हुआ? Today, whether I consent or dissent, then it does not matter. They say the person who is dissenting, then if he gets some advantage only, then he will dissent. Why will he dissent otherwise?
The dissenting creditor
Therefore,
will
if he is dissenting, then he needs that he should be paid the value equivalent to this liquidation value. LV उसको मिलना चाहिए, और LV proportionate में नहीं मिलना चाहिए. They say that 53, if you go to 53, the distribution of 53 is to be seen in only liquidation. Let's not apply the liquidation, you see, principles here. 32B referring to 53(1) is only to the extent of that in what you see where the person stands. Like supposing it is operational creditor is standing below. That's all. So 53(1) अगर refer करेंगे तो उसमें A, B से F clauses आती हैं. They say we'll have to see only those.
So
we don't have to apply entire section 53 because they say it is not liquidation. So because 32B तो पढ़िए ना सर, आप देखिए आप जो बात बोल रहे हैं जो इंडिया रिसर्जेंस में आया, तो इसका मतलब अगर प्रोपोर्शनेटी देना है, प्रोरेटा ही देना है, तो वो डिसेंट करे या ना करे उससे फर्क क्या पड़ता है फिर?
Sir, then the person who are having the more value of the security will always dissent.
तो डिसेंट करे ना, कौन मना कर रहा है सर? लेट देम डिसेंट. ऐसा नहीं होता सर, ऐसा नहीं होता. देखिए नेचुरली एवरीथिंग इज सीन. जिसके पास ज्यादा सिक्योरिटी है तो नेचुरली उनको ज्यादा ही मिल रहा है ना. फिर यहाँ पे उल्टा था, यहाँ पे जो डिसेंट करा उसके पास थोड़ी सी ज्यादा थी क्योंकि उसके पास सोल राइट था, एक्सक्लूसिव राइट था. सो नेचुरली ही सेड ओके आई विल डिसेंट देन बिकॉज आई एम गारंटीड अ मिनिमम वैल्यू. आपने एक मिनिमम गारंटी दी है 32B(2) में, उसको अप्लाई नहीं करोगे? The question is, please let's understand, people actually get confused. Let me also clarify. Section 53 is to be applied in the context of 32B(2) in a very limited manner. That's all. I will not apply full 53 to that effect. Uska effect क्यों? कंपनी को liquidation में थोड़ी आई है. They are simply.
And so I believe DBS was exclusive carve-out.
एक मिनट सर शर्मा जी, अगर सपोजिंग 53(1) को नहीं रेफर करते, वो 32B में कर लिख देते कि ये वाला मैनर में डिस्ट्रीब्यूट होगा नीचे, जैसे ये A to F क्लॉज नीचे रिप्रोड्यूस कर देते 32B(2) में विदाउट रेफरिंग टू 53. क्योंकि चूंकि 53 में था, 53(1) में उन्होंने कहा ओके इसी को रेफर कर देते हैं. So it was only for the practical purposes. That's all it was referred. But minimum guarantee, which is given in 32B, cannot be denied. And I think I tend to agree with this judgment rather than the earlier judgment. Because एक minimum guarantee दिया ना सर, फिर फायदा क्या हुआ? Minimum guarantee मत दो. अब जिसको डिपेंड करना करे ना सर, ये तो डेमोक्रेसी है सर. कौन मना कर रहा है ना करने से?
And the resolution plan below the liquidation value will not be accepted.
सर आप मेरी बात नहीं समझ रहे. आप प्लीज अंडरस्टैंड. अल्टीमेटली जो अब प्लान में उसको पैसा मिलना है तो कौन देखिए अंडरटेकिंग कौन देता है? आरए देता है ना.
यस.
आरए ने सपोजिंग आज 4000 करोड़ का प्लान ले आया, बट ही ऑल्सो गिव्स एन अंडरटेकिंग दैट आई विल कंप्लाई विद 32B(2).
Right.
So if the operational creditors or financial creditors are getting more money, then actually it is a responsibility of the RA to bring in more money. Other financial creditors को कोई compromise नहीं हो रहा. Please understand this. Today, RA has given an undertaking that I will comply with 32B(2). So अगर मेरे को 32B(2) calculate करने के बाद 20 करोड़ extra बनते हैं, then RA is supposed to bring in that 20 crore. Existing financial creditor को नुकसान कहाँ हुआ?
But then if the RA is not ready, no RA is there.
सर उसने अंडरटेकिंग दिया ना, अगर वो अंडरटेकिंग नहीं देगा तो आप तो प्लान ही नहीं पुटअप करोगे, फिर अंडरटेकिंग बेकार होगी उसकी। आरए कैसे नहीं लाएगा सर? अभी इस केस में आप देख लेना, अगर अगर सपोजिंग हायर बेंच यही पोजीशन कर देती है तो पतंजलि विल हैव टू ब्रिंग मोर मनी, आई एम टेलिंग यू, आई एम 100% श्योर. It is not that the other financial creditors will suffer, but it is the RA which will have to bring in more money because of the undertaking they have given.
No, sir, I agree with you. And if I was the RP, I would have insisted upon them कि आप extra पैसा लाके दे दो, and avoid, because he will be
सर वो प्लान में लिखते हैं कि, और तभी क्या होता है टिपिकली व्हाट दे आर आस्किंग टुडे नाउ द आरपीज, बिकॉज यू डोंट नो हु इज गोइंग टू डिसेंट. आप देखिए ये कभी भी एब्सोल्यूट वैल्यू में आ ही नहीं सकता, बिकॉज यू डोंट नो हु इज गोइंग टू डिसेंट, राइट? So the person who dissents, the table and the Excel sheet under 32B read with 53(1) is made after कि अब डिस्ट्रीब्यूशन कैसे होगा. सो डिस्ट्रीब्यूशन के बाद जब देखते हैं तब पता चलता है कि सर इसको तो 10 करोड़ एक्स्ट्रा मिलने हैं, वो उस पूल में से नहीं कटेंगे एक्स्ट्रा. Undertaking has been given by the RA that he will comply with 32B2.
But
So he will have to bring in more money.
But it generally says that the distribution is the lookout of this COC. RA is to bring the value of the
RP has to play a role to see that it is appropriately distributed.
But
it is
COC
RP role also that these calculations are done
एक मिनट सर,
based on valuations.
let me answer Mr. Jindal. Sir, देखिए, you are right. There are Supreme Court judgment which say that the distribution onus is on the COC, no doubt. So यहाँ पे पतंजलि के केस में उन्होंने ओनस डिस्चार्ज कर दिया, कर दिया कि हम प्रो राटा डिस्ट्रीब्यूट करेंगे. वो ये भी कह सकते थे आपको एक पैसा नहीं मिलेगा डीबीएस को.
Exactly.
अगर आप मुझे बताइए, अगर वो उसको एक पैसा नहीं मिल देते तो क्या ये वैलिड होता? So distribution itself can be, which may be unfair. I'm not saying that, but now I have to test it against 32B2. Once I test, because now I know who has dissented. पहले तो पता ही नहीं ना किसने dissent करना है नहीं करना. The moment they dissent, there is an undertaking by the RA that he will comply with 32B2. तो additional पैसा तो लाना ही पड़ेगा उसको. या वो प्लान में उसने लिखा हो कि साहब मैं एडिशनल पैसा नहीं लाऊंगा, 32B2 का जो पैसा है वो इसी से एडजस्ट कर लेना, अगर आपका डिस्ट्रीब्यूशन अपहोल्ड नहीं होता, वो एक अलग बात है. So if RA wants protection, then RA has to put in that clause in the resolution plan. If he is silent on that, then he will have to bring in additional money. Otherwise, there is no option. So therefore, sir, both the things are applied in different silos. First silo is COC has got power to decide. They are deciding. Nobody is disputing that. But now we have to now apply 32B2 in full. Who gets what? So therefore, if he's getting some additional money, then naturally RA has to bring in that money. That is the whole thing, but it really depends.
Sir, those calculations were necessary for RA because DBS is an exclusive charge holder.
Correct. Exclusive and sole charge holder. और उसका LV बहुत high था. See, that was also another point. LV was very high. So you are unjustly denying somebody because वो कहता है जी ठीक है कंपनी को लिक्विडेशन में जाने दो ना, फिर मेरी रिकवरी हो जाएगी. फिर 52 भी तो अप्लाई करो ना सर. अगर आप सिर्फ 53 क्यों अप्लाई कर रहे हो? Then also give him a right in CIRP to stand outside the winding up. कि बोला मैं तो relinquish नहीं करता. वो तो आप उसको राइट दे नहीं रहे हो. तो वो राइट 32B में आ गया ना कि मैं, क्योंकि यही तो कोर्ट ने लिखा अनविलिंग secured creditor is relinquishing unwillingly. So then he must get a benefit under 32B2, which is a minimum value, minimum guarantee. Okay. Chalo, great, sir. I think good discussion on this subject. Naturally, I think.
Sir, can I ask a question on liquidation?
Yeah, please go ahead.
Yeah. So this is Ashish Gupta. So there is an asset under liquidation. There is an industrial plot.
Right.
And the land on authority has not filed any claim. The company is under liquidation, so auction has to go for sale of asset.
Okay.
How to transfer the title? Because I have to pay the pending charges like maintenance charges, lease rent and all.
No, this company is in liquidation or CIRP?
This company is in liquidation.
So now you have to sell the assets, and where there are pendency of the rentals and other things are there, right?
Yes, sir.
ओके, उसमें क्या होता है आशु मैम, इसमें हमने क्या किया, व्हेन आई वाज द ऑफिशियल स्टैंडिंग काउंसिल फॉर द ऑफिशियल लिक्विडेटर इन दिल्ली हाई कोर्ट, व्हाट वी
Yes,
डिड,
sir.
जब भी हम ऑक्शन का नोटिस निकालते हैं उसमें हम पूरा कंप्लीट डिस्क्लोजर देते हैं, लुक दीज आर द रेंटल्स व्हिच आर आउटस्टैंडिंग,
Fine.
now whose responsibility will be to pay, it is also mentioned in the auction notice. So
So that.
you are
Hmm.
just listen to me.
Okay, okay.
You
Yeah,
are
yeah.
you are selling it with all liabilities and assets which are there, rights and liabilities which are there. So you are selling on
Okay.
as is, where is basis, whatever there is basis, isn't it?
Yes, yes, yes.
So therefore, typically the courts have held in high court in winding up matters, the purchaser has to see what are the liabilities associated with that particular property. Either he should ask liquidator to pay first, otherwise, if he takes over the property on as is where is basis, then he is supposed to make the payment.
Okay.
So
Okay.
therefore it will become his responsibility. But आपका अगर आपका ऑक्शन नोटिस बड़ा क्लियर लिख देता है ना ये सब चीजें, तो आपकी थोड़ी कम हो जाएगी, बिकॉज कल को वो ऑक्शन परचेजर कह सकता है कि साहब आपने अपनी नोटिस में नहीं लिखा, सो देयरफॉर यू हैव मिसलेड मी, सो डोंट डू
Yes, I'm
दैट.
writing in the notice, but I'm not quantifying the amount.
नो
I'm not quantifying
आपके पास अगर है क्वांटिफिकेशन
because amount keep on incurring even maintenance charges and that keep on going.
नहीं, आप अपनी उस डेट तक का दे दो ना, द डेट ऑन विच यू आर पुटिंग एन ऑक्शन नोटिस, एक कट ऑफ डेट ले लो ना, लाइक इफ
Okay,
यू
means
आर
amount भी quantify करना चाहिए.
हाँ 100%, जैसे 14 मार्च को आज आप निकाल रहे हो, so you say the outstanding liability of lease rental is concurrent, is continuing, but up to 28th February this is the liability, but it's the continuing
Okay.
liability. So if
It is that.
you need to see papers, you can contact me.
Okay.
So I
I
think
have written, you do your own investigation and all things
हाँ,
like that.
actually let the buyer beware. I think KV tempter का
हाँ,
rule
हाँ.
in contract में sale of goods act में हमने पढ़ा हुआ है, KV tempter,
Yes.
let the buyer
Yes.
beware.
Yes. Thank you, sir. Thank you.
Great. All right. Chalo, I think there are no more questions. Sharma ji, you wanted to say something?
Answered, sir. You have
Acha,
answered.
okay, all right, great. Chalo, I think now we are already at the end now. We have taken a lot of time. So over to you, Manoj ji.
Sir, thank you very much. The topic from started from one point, moved up to another point, but a lot of technicality was involved in it. In fact, मैं तो आपको बड़ा स्पष्ट शब्द में बोल रहा हूँ कि जो आपने जजमेंट ये क्रॉस एडजस्टमेंट की बताई है, आई शैल रीड इट अगेन इन द यूट्यूब एंड देन ट्राई टू रिकैप्चुलेट, बिकॉज अभी तो आई बीन एबल टू अंडरस्टैंड बट नॉट फुली to the extent where I can apply it to in my practice also. Lot of nitty-gritty is there. It need to be me personal opinion is, I don't know about the others, but it need to be recapitulated again. हाँ जी,
हीरा जी ने खुद 4 बार पढ़ी है.
मैं वही कह रहा हूँ. नहीं सर, बात ये ना, इतना बड़ा केस कोई आएगा जिसके अंदर इस तरह से 100-200 करोड़ रुपए की एडजस्टमेंट की एंट्री होगी, वहां पे आप देन यू नीड टू delve into all these things. Otherwise,
judgment has some typical languages.
मैं आपको एक बेंचमार्क बता देता हूँ.
यस सर, बताओ.
अगर आप आरपी हो ना, आपको अगर कम पैसा मिल रहा है तो एडजस्टमेंट कभी जिंदगी में अलाउ मत करना. मैं सिंपल प्रिंसिपल बता रहा हूँ. उसको जाने दो कोर्ट में, अगर कोर्ट अलाउ करती है तो करेगी. आपने अगर आज अलाउ कर दिया, कल को आपके ऊपर एलिगेशन लग जाएंगे. मैं आपको सिंपल प्रिंसिपल बता देता हूँ, बस दैट्स ऑल.
मोरल ऑफ द स्टोरी कि उसको अभी जब बहुत बड़ी, सर इसमें मैं एक बात और ऐड कर देता हूँ, अगर कुछ इस तरह का बड़ा केस आ भी गया कि वेयर बाय एडजस्टमेंट ऑफ थाउजेंड ऑफ हंड्रेड और हंड्रेड ऑफ करोड़ रुपीस देयर, तो वी शैल हैव योर ओपिनियन एज आई बीन डूइंग अर्लियर. So that at least, so that instead of putting my foot in that particular issue as an IP, where my fees is restricted to what I be getting, otherwise also putting my head for such a huge transaction, let me have your opinion and then act accordingly.
Naturally, a legal opinion will always help you.
With the which
lawyers to fight.
No, that can stand with me also, especially if I have from a reputed person like you in my disciplinary and other proceedings also. Same can be suggested to the other IPs also, because you're working as an IP, you're not working as legal expert. For legal expertise, you need to take the help of who are expert in this field. In any case, thank you very much.
Yeah, it helps. Hello,
Yeah,
great.
in fact, I'm telling you, when I got the first case of my Tech Pro, I took sir's opinion. Most probably it was on claim, something like on claim. It happened 4 or 5 years ago. I don't remember exactly, but I took sir's opinion on acceptance of claim like that. That was a small amount, but I took the opinion.
Right.
Thank you very much, sir. Thank
All
you
right.
very much.
Take care.
आप फिर दिल्ली में हो या USA हो?
No, I'm in Delhi only.
Okay. That's
Yeah.
good because your background is very good. So I thought ki you're maybe sitting somewhere. Okay. In any case, thank you very much, sir. We get enlightened as
Delhi
always. Yeah. Thank you. We get enlightened as always. और every IP is aware of it. अगर हम कल आपको दोबारा बुला लेना, तो कल आप और ऐसी चीजें बताओगे जो कि then we shall again feel कि ओहो ये तो पता ही नहीं था हमारे को. The way you discuss these two judgments, it's really marvelous. Thank you very much.
Great, sir.
And
All right.
thank you. If anybody is from the Kerala Insolvency Forum, Mr. P.T. Joy, he can go for the vote of thanks.
I don't think there is any formal vote of thanks required. Okay.
With this note of thank, Mr. Shivanandan ji, you please have a vote of thanks and form a vote of thanks.
मेरा vote of thanks मखीजा जी को हर समय रहता है कि वंदना और चरण वंदना. So I always call him Guruji Pranam. And Vandana and Charan Vandana for such a valuable words of wisdom. God bless you. And please continue to bless us with your words of wisdom.
Thank you.
ये आज आप जो है ना 30 बंदों की तरफ से कर दीजिए अपनी चरण वंदना.
हाँ. चलिए. All the best, sir.
Take care, sir.
Thank you very much.
हमारी तरफ से भी करते हैं सर चरण वंदना. बहुत धन्यवाद.
Yeah. Mukesh ji, आप मेरे से personally बात कर लेना. We shall talk about your claim, and that's all. Thank you very much. I'm closing the meeting. Thank you very much. Thanks a lot. Mukhija ji, आपका बहुत धन्यवाद.
Thank you, sir. Thank you.
Thank you, sir. Thank you, Manoj, sir.
Yeah, we keep on enlightening you like this in the days to come. You're all welcome. All welcome.